All right, ready to go?
Yes, Judge, there is a preliminary matter that both the state and myself want to request. At our last trial, we had asked that witnesses be excluded from the courtroom and from talking about testimony amongst one another. That we had assumed that order would be the rule of the case and would have transferred into this trial. There have been times where there have been witnesses that have, I guess, popped in or something of that nature. And so the parties would be requesting that the court enter that order again.
All right. Is that agreed?
That is agreed, Judge. We just wanted, because there hasn't been a formal order this time, we feel that an order would assist so that witnesses are understanding they should not do things like watch the live feed, et cetera.
To watch. Oh, okay. Anybody who is here as a witness, and attorneys will be obliged to advise those who later arrive as witnesses, we're not here now, that they are not permitted to be present in the courtroom during the giving of testimony. And that will continue even after they testify until the trial has been concluded. And that would also include not listening to or watching any electronic account on television or radio or internet or telephone or anything else. And as I say, the attorneys will be obliged to notify the potential witnesses, and also, you may not, even after testifying, you may not discuss your testimony with anyone who has received a subpoena in the case or has been notified to be ready to testify. No discussion at all about your testimony until after the case is concluded.
Did have in the prior order 4 people were specifically allowed to sit in, even though there had been a exclusion order. And so I just wanted to be sure the court is remembering that and aware of that. And those are Celia Patterson, who's the individual who was testifying when we left yesterday, as well as Sadie Beacham, and then Kayla Petty and Christy Radatz Ortiz. All 4 of those individuals were exceptions last time, and they have watched large portions of the trial.
All right. Any comment?
No comment.
Okay. Otherwise, ready to start?
Yes.
My wife has a medical appointment at, I think it's 3:15. I'll verify that. Maybe 3:45. Thursday. And I will be gone for about 1 hour. Any questions? Okay.
Thank you.
Good morning.
Would you come down, please?
Yep.
Thank you. We'll probably break a little later for lunch on Thursday. And probably take a shorter time, too. Good morning, everybody. Mr. Gravely,
Did you want Ms. Patterson back up to the stand?
please.
So we were on cross-examination of Ms. Patterson, Your Honor.
Right. You're still under oath, ma'am.
Yes, sir.
Good morning, Ms. Patterson.
Good morning.
Going to show you what's been marked as State's Exhibit 54. These pictures, was that something that you provided to the district attorney's office?
Yes, these were also provided to news outlets. Yes, early on.
And you said, but no, that you provided this to the district attorney's office.
That is correct.
In your direct examination, you were talking about how you, when you arrived on the scene on March 28th, 2020, that you had taken a video audio recording of your walkthrough.
Your Honor, I'm going to object. I believe the date's wrong. I think she said March 28th, and that's not listed in the testimony.
Sorry, May 28th?
That is correct. When I was given access to my son's apartment on the 27th, I went in on the 28th. I went into his apartment and sat on his couch to gather my thoughts of what I was.
Judge, I'm going to ask that this be struck. It's non-responsive to my question.
Objections overruled. Go ahead, ma'am.
To gather my thoughts as to what I was looking at, everything. And it took me a good while I was sitting when I got up and I started to do my walkthrough. I did record and did an audio video recording of my son's apartment.
Did you provide that video audio recording to the state?
I did not.
And when you provided the other exhibit to the state, you did that. How many times did you meet with the state to discuss this case?
You know, you're using lawyerese, the state.
Sure. When you met with, when I refer to the state, do you know that to mean district attorneys?
I do.
Okay. So when you provided that picture, who did you provide that picture to?
I don't recall.
Now, how many times did you meet with someone from the district attorney's office to discuss this case?
The initial meeting back in December, and here recently, maybe about 2 weeks ago.
And when you met with them about 2 weeks ago, who did you meet with?
I'll correct myself. It wasn't 2 weeks ago. It was about a week ago. And I met with DA Gravely, ADA Jessica, and Heather, the victim witness advocate.
And did you discuss what your testimony would be?
Not really, not entirely.
When you say not entirely, what do you mean by that?
What I mean about that is expectations of what I asked the questions, what am I speaking to? And they said they really couldn't answer my question. They said that, you know, the questions would come out at here at trial, but just to be prepared to speak about my son and his truck and the picture that Mueller just showed us.
Thank you for providing that little bit of background information. Now I want to take you back to around May 19th, 2020, and I'm sorry to have to do this again. On May 19th, 2020, you had said that you spoke with Aileen Noll.
That is incorrect.
Who was it again that called you?
Kayla Petty.
Kayla Petty. And Michael Campbell, do you know an individual by that name?
He's a very good friend of my son's.
And did he call you on May 19th, 2020 before Kayla Petty?
No,
So you did not talk to Mr. Campbell on May 19th, 2020?
not that I recall speaking with anyone other than Kayla Petty.
On May, you probably might not remember this, but on May 26, 2020, do you remember speaking with Detective Martin Howard?
I spoke with a few detectives, but I don't remember exact date or who they were other than a Detective Correa.
And do you, though, remember talking to a detective about dental records pertaining to your son?
I do.
And do you remember telling that officer who his dentist was?
I did.
And had you been aware of your son's dental records? Did you ever know about, let's say, him having cavities and needing fillings?
Yes, I took him to his appointments with the doctor.
Okay, and to your knowledge, did Mr. Gutierrez have any fillings in his teeth?
Yes, he had fillings.
And if you remember, and if you know, and you might not, there's two types of fillings. There's like the metal one, and then there's the composite fillings, which are meant to look like teeth. Do you know which kind he had?
I do not, I'm sorry.
Do you remember speaking with detectives about, well, strike that. During your direct examination, you spoke to the state about, you kept saying, your son's father. When you were talking in that capacity during direct, were you referring to your husband, Mr. Patterson?
That is correct. Rosario, my pocho's dad, was never in the picture. So when I say his dad, I'm referring to his stepdad, my husband, Eugene, who has been more of a father than his father was ever.
And do you remember telling detectives that your son's biological father had not been involved in his life since he was around 2 years old?
That is correct. When we separated and the judge asked him if he wanted visitation rights, he said he did not. He has never been in my son's life since my son was 2 years old.
And that you didn't have any information about where your son's biological father was, where he was living, what he was doing. You didn't have any of that information.
That is correct. That is something that weighed really heavy on my son, not having that father who wanted him. That's why he wanted to be the best father that he could be.
I'm going to hand you State's Exhibit 37. Okay, you went over these a little bit, but these are the Chase Bank records for the joint account with you and your son, right?
That is correct.
And so I want to draw your attention, it's to page, it says 3 of 6. It's of the April 23rd, 2020 through May 22nd statement. It's kind of in the middle. of the packet. Do you have it? Okay. So page 3 of 6.
I'm there.
Okay, thank you. In these records, do you notice anywhere where your son had made an ATM withdrawal?
I see the one on the 14th and one on the 15th.
Okay, and then you didn't, that was not you, correct?
That is correct.
And the one on the 14th, how much did your son, according to these records, withdraw?
It indicates 700.
And then on the 15th,
An additional 300?
so a total of $1,000.
That is correct.
And naturally, this was what we see in Exhibit 37. This was your bank account too, so you'd be able to access all of these documents, correct?
As he was mine, yes.
And in your reviewing all of these pages, is it a fair and accurate depiction of your bank statements?
It is.
Judge, I would ask to move in State's Exhibit 37.
Is there objection?
No.
The entirety or just the reference
I
dates?
think the just page, the one I referred to, I didn't really question Ms. Patterson on everything else. I don't mind about the entirety going in, but if the court has concern about that, then I would ask it be that specific page that I had been questioning the witness on.
Any objection?
I would just ask the whole exhibit go into evidence as opposed to parsing it out. There had been testimony on direct about some of the other pages, so I would just ask the whole
All right,
exhibit.
it'll be received.
Thank you. I don't have anything else for Ms. Patterson.
Nothing, thank you.
Thank you, ma'am.
Sorry.
State calls Neridia Macias to the stand.
Judge, can we be heard?
Specific exception or objection?
There's an issue about, that we've raised pre-trial about Gravely being a witness to the interview witness. That he's going to have to remove himself from the case.
The reason I always shoo you out of here is because it takes longer to unhook and hook her back up. So it's easier for you to go out. So I apologize that I'm going to ask you to go out again. I'm going to ignore you on. So I'm hoping it won't be too long, but I'm not going to chance and make promises I don't know if I can keep. So please bear with us. Please don't read, watch, or listen to any account of the trial. Please don't discuss the case in any respect. And see you hopefully soon. They're right. They have the option. They can go in the library or they can go upstairs.
Very good. Okay. I just saw that they
That I would have never done.
All right.
Thank you. Judge, March 16th of last year, we went to trial in this case.
I do.
And
I don't think I'll forget so.
none of us will, Judge. So you recall the whole incident with his opening statement, and he talks about having a evidence. He's going to offer evidence about this Neridia Macias and an interview that he had, him and his assistant, had with her at the crime scene, which completely changed the time frame of the defense's whole defense. And so when we confronted him about it, you asked him, well, who was there? Well, his response was, and I'm looking at docket 73, which is the transcript of the jury trial, he said that there was members of the district attorney's office there. And then he was pressed further, and he said multiple people were there. And then I asked you to ask him who specifically was there, and he had finally admitted it was just him and his assistant, and that's all. And you ruled, well, you didn't ultimately rule, but you said, well, that makes you a witness. You took a statement. His defense was that he was not going to, create a report for every single witness that comes forward or everybody that he talks to in trial preparation. But he took a statement from this witness. He is a witness now. He's on our witness list. We have subpoenaed him. He's known this for almost a year. He should have taken himself off the case, but he didn't. So now we're at the point, and I believe your ruling was that we were going to wait and see if this witness actually testifies. We were going to see, how all that unfolded. Well, now it's unfolding, and it's right in front of us right now. And they want to call this witness, who they met with at the crime scene, and it's the whole issue about we went to the wrong building, and we used Google Maps, and all of this stuff. All right? So since he is on our witness list, he is subpoenaed, he's well on notice of this for over a year, I'm going to ask you to remove him from this case. He is now a witness. He needs to be out of the room. He's sequestered. And then the state can call this witness. And then during our case, we'll call him as witness. That's my request.
Well, Judge, I want to indicate what a stunt I believe this is. So first of all, the court had a pre-trial hearing about this where we argued this, and the court at that pretrial ruling permitted the state to remain in the case and indicated that it was not going to remove the district attorney from the case. So we have actually had a ruling on this within the last several weeks. Then counsel, when this witness is called, brings it up and actually says in front of the jury as the description, so the jury gets a chance to hear it, that I should be removed from the case, that the DA should be removed from the case. Then they make an argument that is an identical argument to the argument made to you in that pretrial ruling several weeks ago. There's no change at all in the argument. They indicated to you at that time that they had subpoenaed me, which is also a stunt, that they have placed me on their witness list, which is also a stunt. What the court recalls is the following. The court will recall that in that fateful day where this case was previously held for trial, I was asked a question mid-discussion, and by the way, I am the one who brought up to the defense after hearing their opening statement. I am the one who went to the defense and said, I guess that you should be aware that there was this additional supplemental information that we received. So this was something I told them after I heard their opening statement. I privately approached them and told them that. When we were asked about the details of that, the statute does not require that that be disclosed. The statute specifically requires written and recorded statements. This is not a written statement. It is not a it's not a recorded statement. We had a meeting with Ms. Macias at the DA's office. That had present other members of the DA's office, including our victim witness persons who usually accompany us in those interviews. That's where we talked substantive information to her. Ms. Macias was leaving, and we indicated to her as she was going to drive out that we would go to the same location so she could show us where she had parked over at the apartment building. When that happened, we discovered at that point that she had gone to the wrong building. And so that's how we found that information. We did not know that information until then. We asked her no follow-up questions that I recall. I don't recall any actual interview with her that took place there. We simply explained to her when we saw that, okay, now we understand this is the wrong building. And so that was all that happened. We didn't ask her how this occurred or any of those things. Present at that discussion, where we talked to her, was myself and Ms. Krzyzarek. For some reason, Ms. Krzyzarek is not on their witness list. I'll tell you that in terms of anybody who has a memory of that interaction, Ms. Krzyzarek is somebody who has a memory of that. I barely remember that interaction. In fact, I think that's very clear in the discussion that counsel just provided the court. When I was asked who was there, my thought process was that certainly victim witness was there. When I turned to Ms. Krzyzarek and asked who was there, she is the one who said to me, it was just you and I. I didn't have an independent memory of that.
I can't tell them who
Sure.
they can name as their witness.
I understood. I understand. I'm not saying you can. I'm simply indicating that the way that was then remedied, the court allowed us to talk about whether there would be a mistrial in this case or not. The defense asked for a mistrial. The court was assured by all the parties that this would be a mistrial that would be done without affording any misconduct to any of the parties involved in this case. And so we agreed to a mistrial rather than asking that the court continue at that time. So this was a mistrial that both sides agreed to afford the defense an opportunity to have that information, particularly with whatever issue the court might have in terms of us being a witness. What we then did was remedy it by having Detective Correa, who's sitting with us here, go with another detective, not with anybody from the DA's office, to the location and have Ms. Macias actually explain, without the DA's office being present, where she parked, where she was vis-a-vis that apartment building. So there is a recorded statement of that done on body cam, and that is done so that the defense can see nobody from the DA's office is involved in the collection of that information. It's obviously post that original meeting, but this has taken place. So again, I don't know what we're discussing that was not discussed a couple of weeks ago before this court.
Well, what we're discussing is the only stunt here is Mr. Gravely misrepresenting to this court what actually happened. The fact is that he went out and met with this witness months before trial, didn't tell us anything about it, and then made it a prominent part of his opening, is the point. That wasn't like a little thing. It was a very prominent, and you even said that, it was a very prominent part of their opening, and then he is completely evading his responsibility about this being a statement. He says it's not a statement. You even corrected him, and I'll point directly to docket 73 at page 31 to 32. That's a whole discussion about the court asking Mr. Gravely, who was down there? Multiple people were down there, he says. I want to clarify for the record. And you said, it was not my impression that Mr. Gravely was physically present, and he finally admitted that he was there. And so this whole thing about how we're going to remedy this by sending Detective Carrera out to do that, that's not the remedy, okay? The remedy is to have him leave this case and have them, if they want to call this witness, have them then call the witness, and then we'll call Mr. Gravely after we cross-examine her about her interactions with him, and then we'll get him on the record about what his interactions with her was. And we don't even know, as we sit here today, how many other witnesses went through the same exact process with the district attorney's office.
I can talk about things I don't know about.
Okay.
That you were not glad I did.
Why are we litigating the same thing we litigated 2 weeks ago, other than that we're on national TV? Other than that, what is the possible reason for this to be brought up now when the court made a ruling a couple weeks ago, Judge?
The judge did not make a ruling, Judge.
Just a minute. If I know me, usually this type of thing, I would not have made a definitive ruling. I would have said, as the situation stands now, I would have pushed it off to see, and in fact, my sentiment is right now, I think I'm probably going to push it off to see if we need to, if I do have to make a definitive decision, or if it's one of those many things that we encounter in life that are problems that may just go away.
Your actual ruling was, Judge, that you were going to wait and see, as you typically do. You delay a final decision. You tell us like what you're thinking, but in this case, you said, "Well, let's see if she shows up." Well, she's here.
And let's now I'll make the next move and say, it's like a chess game. I'll say, let's hear what she has to say, and maybe the problem will evaporate. Maybe it'll diminish. Maybe I'll decide it's really not a problem at all. Or maybe I'll have to take some action. If I do take some, first I'm going to take one action right now. You can't examine her. Ms. Krzyzerek can examine her. No.
Judge, I'd like the court to take a look at the minutes from the...
I don't know, if you're going to quote what I said at the last time, you don't need to. I'm saying you're not going to examine her. Without doubt, we're in a perilous area. And we've got 7 days into this trial. Well, actually 9 or 10 when we count the last time. So this is a perilous area. I don't want to get any closer to the edge than I have to. And Ms. Krzyzerek is a very competent lawyer whose assignment to this court I think I enjoyed for 4 or 5 years. And I'm quite confident that she'll be able to handle this issue. And I'm not saying you're off the case. I'm saying she will handle the examination. And then I will await further developments before making a decision on the rest.
You know, regardless of what the court's role is in this, Mr. Gravely has an independent obligation as a licensed attorney in the state of Wisconsin to recuse himself from the case because by definition he's a witness, and by the ethical rules say you cannot be a witness and a lawyer in the same case.
Show me that rule. You can't argue the case to the jury was when I last looked at the rule, it was you cannot argue your own credibility. That was the basic rule. And that's actually why even though I'm going past that, why I stated Mr. Gravely can't examine the witness. But take a look at it and point it out to me.
Can I ask if the attorneys involved here who have an obligation to report ethical violations have reported?
No, you can't, because they're not here to be examined on this issue. And also, if I can tell you, it happens very, very rarely, but when I've had serious ethical violations happen here, usually I handle them with a rebuke, occasionally with a mild censure, but I have on occasion reported people. I commented at the time of the initial trial that while I thought Mr. Gravely had made a mistake, I did not think it was purposeful misconduct, and nothing I've heard since has changed my mind about that. And so I'm not going to report it.
All right. So I just want to be clear, because this record is now is here. It's my belief that what the court said at the prior hearing was that you did not find that there were sufficient facts in the motion or in the argument to remove a sitting elected district attorney from a case of this type. I asked the court to review the report provided by Detective Correa, who indicated what was said, and the court, I believe, indicated that there was no reason to believe that there was a prior inconsistent statement that would make anybody a witness at this point. So that because a purported witness is now available as to the circumstances of this, that that was what I understood the court to do. So clearly, I've been in front of the court a long time. I heard the court make a ruling, and we proceeded accordingly because, of course, we were a couple weeks from trial, or a week from trial. I'm not sure exactly what the date was, but we had a special hearing on this. And the court ruled. I am, in fact, quite surprised that this has been brought up again based on what I heard the court say that time. Not because attorneys can't bring things up again, I suppose, but we heard the court make a ruling. I thought it was guidance to us on the state being able to proceed without any fetters on it. The court is making a slightly different ruling today, and I don't
You know what? I am not going to have the reporter go looking for the transcript or the notes, and then have it go from there, and then everybody wants a transcript and so on and so forth. I think what I said was clear.
Okay. I just want to be sure I had a chance to respond, but I did understand
I
the
think it
court's
was clear what I'm saying today.
So,
And I don't know that I would be very surprised if it's inconsistent with what I said last time, especially when I'm quite sure, as I almost invariably do, I gave you a sentiment as to what I was thinking, but specifically probably told you it was not a final ruling. What did you want to say?
so Supreme Court Rule 20.3.3, the ABA comment 2 makes it clear that that officers of the court, to avoid conduct that undermines the integrity of the adjudicative process, when you're a witness, that the prosecutor cannot simultaneously prosecute a case and be a witness in that case. And you can also take a look at United States versus Schwartzbaum, 527 F. 2nd 249, which is a Second Circuit case of 1975. But also the Wisconsin Supreme Court addressed this in State versus Jorgensen, 2008, Wisconsin 60 at paragraph 38. Testimony from a prosecutor is difficult enough to overcome, but it is impossible for a defendant to test or counter a prosecutor's, quote, testimony, end quote, when the defendant is denied his right to confront the prosecutor as a witness. So that is directly on point with this situation. And I think that the attempts to muddy the water about the history of this by Mr. Gravely is just more testament that that he needs to be examined about his interview with this witness.
Well, I want to take a look at that rule. What's the rule?
I'm sorry? Rule 20.3.3. And all of these sites are in our filing where we asked for him to be disqualified, which is document 77 of the record in pages 13 and 14.
Well, first of all, there's no reason for me at this point to believe that there is going to be any inconsistency in the testimony of the witness and Mr. Gravely's account of it. And I understand we don't have him having given an account, although you could have asked the court for authorization for a deposition or something, but I don't want to get into that discussion. .20.303.
That's what we've got down here, but I'll look it up with you.
Not finding it.
You look at 20, it's not point, it's, sorry, it's colon 3.7, lawyer as a witness.
0.7.
A lawyer should not act as advocate at a trial in which the lawyer is likely to be a necessary witness unless the testimony relates to an uncontested issue, testimony relates to the nature and value of legal services rendered, or disqualification of the lawyer would work substantial hardship on the client. A lawyer may act as an advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded.
Well, 3 sub B, a lawyer may act as advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by 20:1.7 or 0.9. And then under comments, number 2, the tribunal has proper objection when the trier of fact may be confused or misled by a lawyer serving as both advocate and witness. The opposing party has proper objection where the combination of roles may prejudice that party's right in the litigation. I've already stated over Mr. Gravely's objection that I'm not going to permit him to examine this
He should
witness.
also not be allowed in the room at the time during the examination.
You could probably talk me into that. But what in the rules precludes Ms. Grzerek from handling the examination of the witness?
No, I think she can.
Now, I did refer to what was also an ancient rule. I know I define it as ancient because I was taught it in law school. And it was that the lawyer can't argue his own credibility. I'll forewarn you parties now that if credibility is an issue, and it may not be, in fact, maybe Mr. Gravely won't even see the witness stand. But if credibility is an issue, then I probably won't permit him to argue the case either. But that, to me, seems like the outer limits, if we get to that point.
Credibility of who?
Well,
Credibility of who is an issue?
well, that's a good question. I guess I'd have to be, if your credibility comes into issue, or if there's an inconsistency of any kind between your recollection of events and that of the witness here, I think you're probably going to be precluded from arguing anything about the case. But let's push it on.
So,
Just a question, so I can orient myself. I was obviously also present during the interview of Ms. Macias that day.
But you're not on the witness list.
Right, but if then the next tactic or stunt becomes, well, now, say Mr. Gravely eventually has to take the stand, which shouldn't happen because it's not an inconsistent statement, but let's play hypotheticals. So then Mr. Gravely takes the stand. He's already made it pretty clear that his memory is not necessarily sterling, which is why at the previous hearing, he did lean over to me and ask me who was present. So at that point, hypothetically, he takes the stand and doesn't have clear recollections because that's the status of the world given what he does for a living. Then are they then opening the door to then trying to call me to the stand as well? Because I would have the better recollection.
Is this legal jeopardy?
It's the next logical jump in.
I don't want to get into next logical jumps. I've said what I have to say at this point, and that's where we're at.
Judge, first of all, none of this is a stunt.
I don't want to get into.
Defense didn't create
The
any.
jury's in the back room.
Okay. The point is that the issue here is that this witness, this critical witness, significantly changed her story from all the reports we had before that February trial from last year. And so, and those two prosecutors were the only two people with her when she did that.
And I said last time, I thought that was a mistake.
Yes.
And I granted a mistrial because I thought it was a mistake.
And contrary to Mr. Gravely's representation, while the defense agreed to a mistrial, we were forced into it because of that exact flow of events created by him. So I just wanted that to be clear, that this is not something that the defense cooked up. This isn't a stunt.
I don't want to hear any more. There have been jibes periodically throughout the trial, and I've had as much as I want to hear. I want to get this case put to the jury and a true and just verdict reached. Okay?
Okay.
Any question about what the rule is now?
I understand the court's ruling, Judge. Can I just have 5 minutes to reorient myself with the exact exhibits since this was anticipated to be Mr. Gravely's witness? Thank you.
And you were ordering him to be out of the room during this examination.
Again, I would object, Judge. As the court knows, I'm acting as a steward of the evidence and the discussions in this case. I intend to make an argument in this case at the end. For me to not be able to watch this key witness is not appropriate. It's no different than Detective Correa, who was a case officer and who testified in this case.
I will permit you to watch the video of the testimony before argument, if you are going to be arguing.
Okay,
and I'll even let you listen to the audio.
Yeah, I'm going to ask that the court not have the jury have the specter of me not be present. The court has not found that I engaged in any misconduct.
I am going to give a brief instruction to the jury that our attorney rules have provisions about lawyers on the case testifying, and for that reason, I've asked you to step outside the room. I'm not going to say anything assessing any fault or any misconduct or mistake or anything else. Just to explain to you them why you are not in the room. Okay.
All right, so 5 or so minutes.
With the emphasis on the 5. Okay. Would you tell the jury it'll be about 5 more minutes? Thank you. All right, Ms. Kruzarek?
State calls ready to see us in the stand.
Would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated.
Ma'am, could you please state your name for the record and spell it?
Nereida Macias, Nereida Macias, Macias.
And are you currently employed?
Yes,
And how are you employed?
I work for the circuit court as a clerical specialist.
And in what city?
Milwaukee.
And back in May of 2020, did you on a dating app meet Rosario Gutierrez, Jr.?
Correct.
And what dating app was it, if you recall?
Facebook.
And you recall generally the date that you first connected with Mr. Gutierrez, Jr.?
The date, May 12th.
And did you begin to exchange messages with him starting approximately May 12th?
Objection leading.
Sustained.
Did you exchange messages with Mr. Gutierrez?
Correct.
And in general, in the early days of May 12th through the next couple days, what generally type of things were you talking back and forth about?
Religion, spiritual stuff like self-help information, books about his mother, his kids, his job.
Were you getting to know each other?
Correct, yes.
And up until May 17th of 2020, had you met Mr. Gutierrez at all?
No,
In fact, have you ever met Mr. Gutierrez, Jr.?
no.
You indicated that you and Mr. Gutierrez Jr. talked about family and different things like that.
Yes.
What's important to you in life?
Objection relevance.
Seems marginally relevant,
I would agree.
very marginally. So if it's short, I'll,
Very brief, Judge.
okay.
So ultimately, did you and Mr. Gutierrez Jr. make a plan for May 17th?
Yes.
And did you do that over the phone via text messages?
Yes.
Now, prior to May 17th of 2020, did you know where Mr. Gutierrez lived?
No.
I'm going to direct your attention to the television screen. And this is on State's Exhibit 1, number 344. Ms. Macias, do you recognize this phone number up here at the top?
Yes, that's mine.
Okay. And would that be a nickname for you as well as your last name?
No, yes.
And do you recall asking this question of Mr. Gutierrez Jr.?
Yes.
And what is that question that is up there?
What town do you live at?
And he then responds with Kenosha. Is that accurate?
Yes.
And he then gives you a little bit further information. I live right by UW Parkside.
Yes. Yes.
Now, at this point, were you developing a plan for you to come down and meet him?
That day, yes.
And do you recall if there were suggestions about different things that you guys could do, you know, given the status of the world back in May of 2020?
What do you mean? I'm sorry.
Well, let's move on to your next message. Does it read, "What's open" from you?
Yes.
And then you ask, "Around by you?" And he responds, "All the Kenosha bars are open." Is that accurate?
Yes.
And do you recall your response being, "We are not going to a bar"?
Yes.
And why is that?
Because going to the bar, obviously you're going to drink. I'm not going to drink and drive, only because of where I work at.
And ultimately, what did you guys decide would the plan be on May 17th that evening?
The plan was to pick them up and go out, I don't know, just drive around and get to know each other, basically.
And so as part of that plan, did he text you his address?
Yes.
And direct your attention back to the screen. This is now page number 151 of State's Exhibit 1, number 344. And would the address that he texted you on May 17th at 6:58 p.m. be 3709 15th Street, apartment 1B? Is that what he texted you?
Yes.
Now, once you had that address in your phone, what did you do to look up where he lived?
I looked it up on Google Maps to see where exactly he lived. It did, in the beginning, kind of scared me because I wasn't sure it was a good idea to go or not. But his personality really caught my attention. So I went for it and drove out there. Here.
And showing you that same exhibit again. This is specifically page 149. So at approximately 6:56 p.m., he tells you, "No worries, take your time. I still have to drop off Ava and she lives 45 minutes away." Is that accurate?
Yes.
And you respond with an okay?
Yes.
Then is it you that sends him a message saying 8:30 or 9
Yes.
with some question marks?
Yes.
And he responds 9 will be safer?
Yeah.
And you say okay? Then we get into where he gave you his apartment address.
Yes.
And then did he give you the full address at approximately 8:15 p.m. on the 17th, including Kenosha, Wisconsin, 53144?
Yes.
At some point, does he tell you that, according to his GPS, he'll be home at 9:01 p.m.?
Yes.
Direct your attention back to the screen. And as your conversation continues, at approximately 8:25 p.m. Does he tell you, see you soon?
Yes.
You say back K. Is that accurate?
Correct. Yes.
Then he asks if you want him to pick you up anything to drink, Corona, Bacardi, or Jameson.
Correct.
And you indicate you'll settle for a beer. Does he then indicate to you other drink options?
Yes.
And is your response water is perfect?
Yes.
And then I don't want to get a DUI? And he then texts you, I understand.
Yes.
So after receiving that last message, do you then proceed down to Mr. Gutierrez's residence to meet him for the first time?
Correct. Yes.
And what map program were you using, if you recall?
Google.
And so did you put in the address he had given you of 3709 15th Street 1B into that map program?
Yes.
And then were you texting him updates about your progress?
Yes.
So I'm going to show you once again up there. We left off with him saying, I understand, at 8:27 p.m. And then at 9:37 p.m., is that you indicating you're 5 minutes away?
Yes.
And then at 9:43 p.m., indicating I'm here?
Correct.
And then at 9:44 p.m., asking where do I park?
Yes.
And at 9:52 p.m., are you okay?
Yes.
And at 10:05 p.m., I'm worried about you, are you okay? And then at 10:18 p.m., indicating I left. And I'm gonna scroll back up to the top of page 158. After Mr. Gutierrez has sent you, I understand, and it says delivered. When looking at your messages, what is the status of each message that you send after that, if you can tell?
It says unread.
And that's on each of these are unread?
Yeah, it says unread. Read. Read. Unread.
So after 8:25 p.m. when he texts you, I understand, do you hear anything further from Mr. Gutierrez Jr.?
No.
To this day, have you ever heard anything further from Mr. Gutierrez?
No.
Now I'm going to show you a map of the Wood Creek apartment buildings. Now when you came down to meet with Mr. Gutierrez, can you, with a pointer, Judge, can I get the pointer from you? Ms. Macias, if you could take this pointer, and can you go up on this map and explain when you came into this apartment complex, where you went, and then where we're building the apartment front of?
I'm sorry. I pulled in through the driveway and I parked right here.
And is that where your GPS took you to that building?
Correct. This building.
And when you first pulled in and parked right there, what did you do next in front of that building?
I waited a few minutes because I was nervous. I really wanted to get to know him. So I figured the door's like right here. So I pulled in a little closer by some dumpsters and I waited there for a couple minutes more.
And do you recall what the weather was like that night?
It was like drizzling. It was kind of like raining.
Okay. And obviously you got there at sometime around 9:30, 9:45 p.m. Was it dark out?
Yes.
And so besides parking in those locations you've talked about in front of that apartment, what else did you do, if anything?
Since I wanted to see when he came out, I parked across I saw a guy that moved out his vehicle, so I parked right in front of the door so I can see when he comes out, and I can just kind of flash my lights. But he never came out.
And ultimately, you then left the area and went back home?
I waited there a few minutes, but he never came out. So when I pulled out, I ended up parking right here. And I kept texting him, "Are you okay?" I don't know if he was in the shower or married. I did not know, so I left.
You can grab a seat, thank you. Now, prior to that night, had you ever been to what is commonly here called the Wood Creek Apartments before?
Never.
Were you familiar with this area of Kenosha?
No.
No. After giving that statement to law enforcement about your interactions with Mr. Gutierrez that night, do you recall having a further meeting with Detective Correa in March of 2022?
Yes.
And what was the purpose of that meeting, as you best recall it?
To talk about what exactly happened at the location.
And what type of questions did Detective Correa ask you that you can recall?
Where my GPS guided me to exactly, and how long was I waiting between pulling out my vehicle.
And did he ask you essentially a lot of the same questions I've asked you today?
Yes.
Now, back in 2020, when officers first spoke with you, did they have you come down to the scene and talk them through anything?
No.
So how did they interview where did they interview you the first time?
At the Kenosha police station. I actually came from Milwaukee because I saw on Facebook. Since I was not friends with Rosalio on Facebook, I was kind of curious. How come I didn't hear from him Sunday, May 17, 18, 19? I didn't hear from him. So I looked on Facebook and it said, "Have you heard any information from Rosario Gutierrez? Please report to police." So I drove down personally to speak with Kenosha police because I was concerned. And then I spoke with the detective and I explained to him what happened, or is everything okay? And he asked me some questions.
And when you first spoke to Detective Correa, he didn't take you to the scene to walk him through anything?
No.
But the second time you spoke with Detective Correa, you actually went to the scene to walk him through exactly where you parked and what you had done?
Objection, leading.
During your second interaction with Detective Correa, did you actually physically go to the scene? In terms of where you parked?
Yes.
Did he share with you that the building you actually were in front of was not 3709?
Objection, leading, and hearsay.
Stand.
The building you pointed to up there, that's where your GPS took you that night?
Correct. Yes.
Now, I know that you had testified a little bit earlier that you had only been speaking with Mr. Gutierrez Jr. for approximately a little less than a week. Is that accurate?
Yes.
Did anyone in your life know anything about him?
No.
Had you been talking to him about him to family and friends or anything like that?
No.
Was there anyone in your life at that point that would be jealous if you were talking to someone on Facebook dating app?
No.
Last question. So since 8:25 p.m. on May 17th, when Mr. Gutierrez Jr. texted you back, I understand. Have you heard from him at all?
No, not at all.
I have no further questions. Thank you. No, ma'am, you have to, sorry, they get a chance.
Oh, and I'm just gonna grab the, cord.
Gutierrez gave you his address, that you put it in to Google Maps. Do you remember that
Yes.
testimony?
Yes.
You're standing by that testimony?
Yes.
You sent Mr. Gutierrez a screenshot of you putting his address in, correct?
Yes.
Judge, sorry, there just seems to be some connective issue. Well, it's weird because it flickers on. So I pulled up, oh my gosh. Do we have another one?
Please don't talk about the case during the break. But 10 to 15 minutes. Right, go ahead, Ms. Muller.
State's Exhibit 344, page 153. Ms. Macias, this is the text message that you sent to Mr. Gutierrez with a screenshot of your maps, correct?
Yes.
And you had an iPhone, correct? I'm going to show you what's been marked as Defense Exhibit 237. This is the screenshot that was in that text message, correct?
Yes.
And in this, it's your address to 3709 15th Street. And it's saying that it's going to take a total of 37 minutes. Sorry, if you could just say yes or no for a minute.
My apologies.
Reporter.
Yes.
And this screenshot is actually from Apple Maps, correct?
That's Apple Map?
So you
Yes.
didn't use Gmail, you used Apple Maps.
I used Gmail and Apple Maps. I don't know if it was the second time when I went out there to meet with the detectives, so it must have been. So I must have used Apple Maps to meet up with him, but I must have used Google Maps to go see the detectives to meet up with them for the scene.
Okay, so when you
So I must-
went on May 17th, 2020, you used Apple Maps,
Okay.
correct?
Yes.
And it would take you 37 minutes according to Apple Maps.
Yes.
I'd ask that Defense Exhibit 237 be moved into evidence.
Any objection?
No.
Received.
Correct, thank you. It was on, it's a digital display. It's just taking. So, in your text messages, you and Mr. Gutierrez had agreed to meet at 9 p.m., correct?
Yes.
And you sent that screenshot that said 37 minutes. And do you remember texting Mr. Gutierrez at 8:24 p.m. that you were going to start leaving your house?
At 8:24.
Correct.
It's around 8, but I can't remember the times. I need to see the time. Sorry.
Pull up what's marked as Defense Exhibit 236. Okay, so the message in the blue is your message, correct?
Yes.
Okay, and you send a text that says, okay, no worries, I love driving, it'll give me time to jam more, I'm gonna start leaving my house. That was at
Yes.
8:24,
Yes,
correct?
yes,
Your plan was to meet at 9, correct?
correct.
So 37 minutes from 8:24 would be around 9 p.m., correct?
Correct.
Now, in your text messages and in your direct testimony, you said that you're there, I'm here, at 9:43 p.m., correct?
Yes.
And prior to that, you didn't text Mr. Gutierrez that you were running 40 minutes behind, did you?
No, I did not.
You didn't call him and tell him you were running behind, correct?
No, I did not.
And he didn't call you asking you where you were, correct?
No.
And he didn't text you asking where you were.
I'm sorry.
Is there an answer?
No.
Could we have the witness speak directly into the microphone? We can't hear her at all over here.
When I
Is
said,
it on?
is there an answer, are you answering no, there was?
Oh, I was
not an
saying-
answer, or no, that was the answer?
No, that was the answer.
No was the answer.
Yes.
The first question. Let's speak into the mic, please.
So, you also testified about how it was your plan to drive around, to meet up, come and drive around.
Yes, to get to know each other. I was too afraid to go to his house. I didn't want to go in there. I just wanted to basically get to know him and just get to know him a little better.
But you didn't text about that plan, correct?
No, I didn't.
You didn't talk to him that day about that plan, correct?
We did earlier when we were actually talking, when I was working.
On the phone.
Correct.
So what was the plan then, for when you got there? At 9 p.m., what was the plan?
Don't know. We just wanted to get to know each other once I got there and see what was the plan. Either go to a bar, to a restaurant.
Well, I'm asking more about the specific details of your plan. You said that you were waiting outside for him to come out. Did you talk about that he would come out to meet you?
I think his plan was maybe for me to come in, but I would not go in there. My plan was just to sit outside, maybe in the car, and just get to know each other.
So his plan was for you to come in, but your plan was for him to come out.
Correct.
So what plan did you make that you solidified of what would happen when you arrived there at 9 p.m.?
What plan did I make?
I beg your pardon?
I'm sorry, could you repeat that question?
You just previously you testified that the plan was he was going to come out and you guys were going to go for a ride together. Just now you testified that he wanted the plan according to him was that you were going to come inside.
I'm thinking maybe he wanted me to come in. I don't know what was he thinking, but I can tell you that my plan was for him to come out. I don't know if he was.
Okay, so that was just your plan. That
Right.
wasn't something that you guys discussed and agreed
No,
on.
not at all.
Okay, so you didn't discuss that when you had the phone call with him earlier then?
We just planned to just meet up with each other. That was the plan.
At 9 p.m.?
Yes. It could have been earlier, but he had to drop off his kids, and I respect that.
So, May 20th, 2022, you upon yourself just show up at Kenosha Police Department at 7 a.m. in the morning.
Correct.
No one had reached out to you to
No.
come provide
No.
things. You went on your own accord.
Yes.
And do you remember that when you went to meet up at Kenosha Police Department, that you had materials that you were going to give to the detective you spoke to?
Yes. My phone of the conversations I had with him and the conversations I had prior, which was the Facebook meets or Facebook dating app.
And those were screenshots, correct?
That day, no.
You didn't give any screenshots to the detective on May 20th, 2022.
Not that day, because they were going to meet with me again.
Okay, do you remember, strike that. I'm going to show you it's been marked as Defense Exhibit 235. Show you what's been marked again as Defense Exhibit 235. This is an email that you had sent to Detective Pereira on May 20th, 2020, correct?
Yes.
And at around 8:26 a.m.
Correct.
And the subject is forward last text messages I had with Rosario, correct? But his name is, that was a misspelling, correct?
Yes.
Okay. And in there you wrote, I'm forwarding over the extra information you asked for as an attachment to this email.
Yes.
And the attachments were screenshots.
Yes. Now I remember. Yes. Those I sent those out. I remember those. Yes.
Okay, so this is a forwarded email.
Yes.
Did you email yourself these screenshots prior?
Forwarding. Yes, I did. I kept those for my copy purposes. That's fine.
So at what time though? Did you provide that email that you had forwarded to law enforcement?
Your Honor, I'm objecting to the relevance of that. She testified she provided these screenshots as been identified. What does it matter if she forwarded them to herself first?
I sent them to him because that's what he
Not
asked for.
asking about you sending them to him.
Don't cut off.
Sorry. Not asking if you sent them to him.
No, wait.
Good.
Okay, I sent them to him because he asked me for them. But I don't know if I sent them to myself or did I resend them to him because he must have said, I did not get them. I can go back and look at my email. I'm more than happy to do that.
So let's go through the screenshots. So this screenshot that you sent, and it's terrible quality, I'll try to zoom in. It might be that I have to hand you the actual exhibit. I'm going to hand you the actual exhibit just so you can see the text. But this is one where it starts about what are your plans tonight, and then basically would you be interested in meeting up? Is that an accurate depiction of what that text string is?
Yes.
Okay. And this screenshot was taken at 8:03 a.m., correct?
Correct.
So this screenshot then you had taken the day before?
What date is that?
So you emailed these as a forwarded email to Detective Carrera on May 20th, 2022.
Yes.
This is a screenshot that says the time that this screenshot was taken was at 8:03 a.m. You agree that's the time that's up on the top, correct?
On May 19th?
I'm asking you, what date did you take this screenshot?
I don't remember.
Did you take any screenshots when you were meeting with Detective Carrera?
Oh, I don't remember. No. I sent those I sent those the moment he asked me for them, but I don't remember the dates when I sent them.
Okay, so when I'm asking, you don't remember then when you took the screenshot?
No, I'm going to object to ask and answer. That's been asked 2 or 3 different ways at this point. She's indicated she does not remember when the screenshots were taken.
Her answer was that she doesn't remember when she sent them. She hasn't answered as to when she took them.
Did she say that she had taken them
Yes.
or that she received them from someone?
No, that she had taken them.
Well, how would it be a forward?
Well, her testimony, Judge, was that she didn't remember when she had forwarded the email, but my understanding was that she had sent them to herself. She said she had sent herself her own copy. So, do you remember what date you took this screenshot on?
No, I don't.
I'm going to go to another screenshot that you sent. I might need to hand this to you if you can't read it. But this was a screenshot that was taken at 7:10 a.m., correct?
Yes. The time is on top. 7.
Sorry?
The time is on top.
So at 7:10, were you already at Kenosha Police Department?
I'm just trying to figure out what date that I did send them, but I was over there around the time, 8 o'clock in the morning.
So if you were there around 8 a.m., we know it takes 37 minutes to get to your house or get to Kenosha around. Did you take this screenshot early that morning or the day previous?
I think previous.
So then it would have been May 19th at 7:10 a.m.
I'm sorry, I don't know. I'm sorry, I don't know. I would have to go back and look on my phone again. I would
Okay.
have to reopen my
Well,
phone.
that's fine. We'll just go to a different one. This was another attachment you sent with the timestamps, correct?
Yes.
The time on that's 2:44 p.m., correct?
2:44.
At the top, the time that you took the screenshot.
Yes.
Because, I think this is common knowledge, but maybe perhaps not. When you take a screenshot on your phone, it's going to depict
Right.
whatever's on your phone, right? So your understanding is that if that time showed up, that would have been the time that the screenshot was taken on your cell phone.
Yes.
Okay. So you're with Detective Carrera in the early morning hours on May 20th, 2020. You'd agree that it would be physically impossible for you to have screenshot this text on that specific date, correct?
I'm going to object if possible. I think it's a mischaracterization, and she said she was there in the early morning hours, which opens up the possibility of a lot of time that day. So I think it's a mischaracterization of what's been testified to.
I can rephrase and go through it a little in more detail. I'll go back to the time you sent the email. You sent the email at 8:26 a.m. on May 20th, 2020, correct?
Yes.
This screenshot is taken at 2:44 p.m., correct?
Yes.
So it would have
Yes.
had to have been taken on May 19th, 2020, correct?
Yes.
So knowing that now, does that help refresh your memory as to what date you took the other screenshots on.
Correct.
So this would have been taken at 7:10 a.m. on Monday, May 19th.
Yes.
And the other screenshots, the ones from 8:04 p.m. or 8:04 a.m. were also taken on May 19th, 2020, correct?
Correct.
Now, these screenshots that you sent Detective Carrera, they're not an entirety of the string of messages that you had with Mr. Gutierrez, correct?
The string of, you mean like the conversation I had with Gutierrez?
Yes.
That's the only thing I had.
So I'm going to give you Exhibit 235, and I want you to show me which attachment shows the text message that says that you're about to leave your house at 8:24 p.m.
You said at 8:40 or 8:20?
At 8:20, the one that I read to you earlier.
That's not here.
Sorry, can you say that louder?
It's not in this, it's not on these sheets.
So the attachments that you sent didn't include that message, correct?
The attachment, what that I sent to the to the detective, I sent him everything.
But you just said that you looked through this
I looked
exhibit,
at that one, it's not on there.
and it's not in there, correct?
Yes.
I'd ask to move Defense Exhibit 235 into evidence.
Objection?
I would ask that it be subject to cross or redirect,
I would ask that
I guess. It
something
be subject to redirect on it before it's officially moved into evidence.
well, seem it's subject to your recross.
Yo.
Why didn't you just hand Detective Correa your phone to be able to look at the text messages?
I did.
And did you allow him to complete a Cellbrite download or a download of your cell phone?
He had mentioned there was going to be 2 officers coming to my home to speak with me. And those 2 officers, I offered my phone, and they said, we just want to see the text messages. And then they sent it to themselves.
The detectives took your phone and sent themselves the messages?
Yes.
Okay.
Our
And
officers, I don't know if they're officers or detectives, but they reviewed my phone.
but they never took your phone completely to
No.
run any tests on it?
No.
Now, you said that you went to Kenosha Police Department the morning of May 20th, 2020, because you had seen a Facebook post,
Correct.
but you weren't friends with Mr. Gutierrez on Facebook.
Correct.
So what Facebook post did you see?
Since I didn't hear from him the 3 days that I was just kind of like, what's going on? I was like, maybe he's married or, is he not interested or what? But I saw on Facebook, it said in public, if you hear anything from Rosario Gutierrez, please contact Kenosha Police. So I'm thinking like, oh my God, what happened? So right away, I took the day off and I went straight I came here to Kenosha Police Station and I spoke with the detective and I explained to him not explained, but I asked him
Is there something that I'm missing? Is this guy, what's going on? And he started to ask me information, like, how do you know Rosalio? How did you meet him? And I explained to him, like, I don't know too much about him. I just know a little bit of what we talked about. I gave him the whole conversation of what I had with Rosalio last.
So, but back to the Facebook post. Who posted it?
I don't know.
Did you show detectives the Facebook post that you had seen?
No, I just seen it on Facebook and I just never.
At what time did you see it on Facebook?
See, I seen it at nighttime. So it was like, must have been like a Wednesday night. The 20th was a Thursday, right? Is that correct? It was the night before. I know it was the night before, and it was a nighttime. And I said, "Oh, geez, I gotta go over there and see what's going on."
You got to go over there.
Like come to Kenosha and find out, like, is everything okay? Because I don't know. Like, I had the conversation last, and me working at the time period for the district attorney office, my job is important. I'm a mother. I don't know. I just thought the best thing to do was to give the officer my phone.
Okay, so May 20th was a Wednesday. I want to go back to the Facebook post. So May 19th was a Tuesday. So you're saying you saw that Facebook post the evening hours of May 19th, 2020?
Yes.
So not in the morning?
Not in the morning.
So not around 7 or 8 a.m.?
I know it was like a day or 2 days after. Yeah, it must have been 2 days after. Because I was so concerned, like, he never got back to me. I kept messaging him.
Wait, I want to go. Sorry, I'm just asking about this Facebook post. So I'm going to keep it to that.
Yes.
So it wasn't around 2 p.m. mid-afternoon either. It's later than that. You see this post.
Correct.
So I want to go back now to May 17th, 2020. You thought you used Google Maps on that day, but now after seeing your screenshot, you know you used Apple Maps on May 17th, 2020.
Correct.
And when you spoke with officers, I believe it was on the 22nd, you spoke to someone other than Detective Correa, correct?
Yes.
And you had told those officers that you were outside of Mr. Gutierrez's apartment building, right?
Yes.
And when you got there, you could see the numbers on the apartment building, right?
Yes. No, it was kind of dark. I'm just following by what the maps was telling me, so it was kind of dark.
I'm going to show you what's been marked as Defense Exhibit 58. Does this look like the front of the apartment building that you were waiting at?
Your Honor, I'm going to object. Wood Creek Apartments, they're essentially all identical, so in terms of being able to, if you asked about the address specifically, if you saw that, I think that's appropriate, but all of the apartment complexes are identical, so whether she's in front of this one or one that looks identical would have to be determined by the address, not necessarily.
You're testifying right now. You can cover this on your redirect. Although the point may be a good one, and so.
She was there, Judge.
Understand?
They all look the same. They really do look the same. The same door, the color of the door, from what I'm seeing right now.
The taped door looks...
No. It's just the color of the door.
Okay, but there's numbers on top of the door, correct? Can you read the numbers that are...
It says here 3709.
Okay, thank you. So Apple Maps could have taken you to the correct address, right?
Tanner, I'm going to object. She testified to where it took her. Whether or not it could have taken her to the right address, I think is irrelevant. She's testified under oath where it took her.
Judge, on direct, the state said, oh, you took Google Maps, and Google Maps took you here. We now have that she took Apple Maps on May 17th, 2020. Completely different maps. So
No.
I'm able to go into this.
Well, I just want to make sure this defendant who's giving the testimony, and then the attorneys talking about things that haven't actually been produced in testimony. So again, I'll think you can cover on.
Can you repeat your question?
Yes,
With
please.
respect to the questions by the attorneys, occasionally lawyers, and we're all guilty of it, will form questions in such a way that assumes facts and then asks the witness to affirm them. And sometimes the witness takes a different course and doesn't directly respond to that. Keep in mind that if the witness does not affirm what the question presupposes, then it's not reflective of the witness's answer. Any question about that? Okay.
So it's possible that on May 17th, 2020, you were taken to 3709 15th Street.
You're tell.
You know, you're asking, was taken?
Sure,
Direct, is that what you mean?
Sure, I'll rephrase. It's possible that Apple Maps would have taken you to 3709, that building, on May 17th, 2020.
But it didn't guide me there. It guided me a whole different building. That's what I'm realizing.
But you said okay, so later in March of, what was that, 2022, correct?
Yeah.
2 years later, you used Google Maps to return to the Wood Creek apartment complex.
Correct.
And when you used Google Maps, it took you to the building you pointed out during direct.
Correct.
But they all look the same.
Yes.
So it's possible that when you used Apple Maps directed you to the other building. The actual building.
The actual building. It never sent me to an actual building.
But, okay, so March of 2022, you actually had gone back to that location before March 2022, correct?
With the DA and the detectives.
No, I want to talk about, the time that you went to the scene only with the district attorneys.
Well, with the people from the district attorney's office, is that what you mean?
People from the district attorney's office. You remember that meeting?
Yes.
And who were the people of the district attorney's office that you met with?
The district attorney, I'm sorry, I forgot your name. I'm so sorry.
Ms. Kazarian?
I'm sorry, how do you say your name? Yes, Jessica. And it's another gentleman. I'm sorry, I can't remember his name.
Can you describe what he looked like?
He's a very tall gentleman.
I'll stipulate it's DA McGravely.
The district attorney?
Yes.
Yeah, okay.
And how did that meeting come about?
He called me that day and he's like, "Where are you?" And I'm like, "I'm at the building where it's."
Sorry.
I'm going to ask the question. She's answering the question. I believe it should be fully answered before we move on to the next question.
I'm gonna withdraw that question and rephrase it.
Well, you can't interrupt the witness. Did you understand the question?
Oh my God, I'm so sorry. Can you ask me the question again, or?
Sure.
All right, go ahead.
So prior to you meeting with District Attorney Mike Gravely and Jessica Kasterik, how did you know to go to that location?
How do I know to get to that location? Because the DA gave me the address and said, I will meet you to that location so you can explain more detail where you parked. I said, okay.
So did you call the district attorney or did the district attorney call you?
They called me.
And do you remember the district attorney telling you that there's something off with the timeline?
Just the map. It was kind of like the Google Maps, and we were just kind of figuring out the map. Why did my phone directed me again to the same location where it sent me the first time?
And Attorney Gravely had asked you to do that, correct?
I'm going to object that they asked her to do what?
Asked you
Yeah.
to do that? Question was asked you to do that?
It's vague.
That's what, it was a follow-up to her answer just now about comparing the map to your phones to Google Maps. Attorney Gravely asked you to do that, correct?
Just to kind of review my phone. And I showed him my phone. This is where my phone directed me to that other building.
But he didn't ask you to pull up it on Apple Maps, correct?
No, not that I remember.
And that was approximately 2 years after you had been to Wood Creek Apartments in May of 2020, right?
No, that was like a year ago, 2 years ago. Like a year ago. No, it was a year ago after I met up with him. It was a year.
So back now to the Apple Maps. Is it possible that where you were when you met with the district attorney is different than where you were on May 17th, 2020?
No, it was the same location.
How do you know it was the same location?
Because he called me and said, "Where are you?" And I said, "I'm right here where I was waiting for Rosalio." He said, "This is not the building. The building's over here." And I said, "Well, you can see for yourself." And I showed it to him.
But you previously testified that all the buildings looked exactly the same.
Yes, they all look the same.
So how do you know you were at a different building?
Because the phone had a little red dot that pointed to me that was the building.
But you were using Google Maps.
I'm going to object, ask and answer. I think now we're on, time 4.
Well, the organization leaves something to be desired. Let me rephrase your question. Let's take it from there. As to what event she's talking about, and what the source of her information was, and the impression that she formed as to where she physically was.
Did you look at the apartment building numbers at any point?
I did not really pay attention, only because I was only going by what the map was telling me.
Okay, so then,
Sorry,
And then-
Jen, nobody can hear.
Yeah, I don't know what's going on. It's been a couple of months that the sound has been worse and worse. And it's not your fault, ma'am.
Sorry.
Unless that green light isn't lit, because then
It's like,
press the bar in front. Yeah? No, I don't know. We were
Can you hear me now?
I'm having terrible trouble with that, hearing from that microphone.
can you hear me now? To me, all the buildings, they look the same. The moment you drive in, they all look the same.
but when you met with the DA's office, you used a different map application.
Correct. The Google.
So it's possible where you were on that day is different than where you were directed previously.
Your Honor, I'm going to object. This has been asked and answered multiple times. She indicated she went to the same place she had been directed before and was surprised that we weren't there.
We covered it.
I'm not sure. All I can say is, for some reason, God guided me that way, and I don't know why. I arrived at that same building 2 times. I arrived at the same building two times. Both maps, both times I put it on there. If I put it on there right now, it'll probably guide me there again. I don't know.
So, but you didn't use Apple Maps when you met with the DA's office, correct?
When I went to the DA office, did I use Apple Maps? Is that what you're asking me?
When you went to the Wood Creek Apartments, when you met the district attorneys there, you did not use Apple Maps.
No, I used Google.
So you're saying all the buildings look the same. You used a different application the second time to get there. So all I'm asking is it possible that on May 17th, 2020, you were actually in front of 3709 15th Street?
Your Honor, I'm going to object. She's indicated she didn't really look at the numbers, and she said where she was on both dates. So we have asked this question multiple times. She's answered it multiple times, and we just keep going in circles trying to get a different result.
Judge, she hasn't answered the question. Her answer to the question each time is she used Google Maps and everything looks the same. So I'm trying to break that down, and we know she testified earlier that she used Apple Maps on May 17th, 2020, and she's not been able to provide an answer as to how she knows definitively that while using a different application, she arrived at the location that she were directed to Apple Maps on May 17th, 2020. I'm simply trying to get an answer to that.
I think the subject has been extensively covered, and it may be that the clarity that you're seeking isn't there.
You didn't read any of, on May 17th, 2020, you didn't look at the apartment building number.
On May when?
17th, 2000?
No, because it was dark and it was rainy.
You said you had your lights on?
Yes, but my vehicle is not that. It was an old Toyota that I had that's not even that bright. So I couldn't even see myself. That's why I said I wait for him to come out. I'm not gonna.
But you said that you pulled up, right? So you said you pulled your car up, that you were back by the dumpster, correct?
Correct.
And that you pulled your car up to a closer up spot.
Correct.
Which would be approximately 10 feet from the building, correct?
Correct.
With your lights on.
Correct.
And you're saying you didn't look and read what you read today, which was 3709 apartment building number. You didn't read it.
No, I didn't. I was more worried for him to even come out. I was nervous. I wanted to get to know him. All I remember seeing is a heavy-set woman coming down the stairs. There's light in the hallway, and some young guy was going down the stairs, and then he went back up. I don't know. I didn't want to get to the door and ring the doorbell or anything because I wasn't sure if it's one of those apartments that they have to buzz you in. You're not going to stand in the rain.
No, you just said that you observed we'll talk about what you observed now. You said you observed a heavier set woman going up and down the stairs?
Yeah.
Do you remember on May 22nd, 2020 saying that you saw a Hispanic male going up and down the stairs?
It was like a Hispanic male, yes.
And that you actually saw a heavier set black female woman with a bag enter the apartment building?
Correct.
So you didn't see are you mistaken that you saw the black female woman going up and down the steps, that you had just seen her go in?
Yes.
Okay. And so, and you said that you could see what was going on in the apartment building.
Correct.
So you were close enough to observe what was going on in the apartment building.
Yes.
And do you remember being asked if you saw any vehicles around the area when you were there on May 17th, 2020?
I saw like another Toyota, like a blue Toyota, driving past me with tinted windows, but didn't really pay attention to that.
Do you remember saying you saw a white four-door vehicle as well?
There's a lot of vehicles there, so I didn't really pay attention to other vehicles around me. Everybody's vehicle was parked.
If I was to show you wrote a statement in this case, correct?
Yes.
If I was to show you that, would that help refresh your recollection?
Yes.
Oh, I thought you were talking. Excuse me.
Did that help refresh your memory?
Yes.
Okay, so do you remember telling officers that you saw a white four-door vehicle as well?
Yes.
So I want to go back to your screenshots. That's exhibit 235. Do you remember sending this screenshot with the timestamps of when you sent your message to Detective Correa?
Do I remember when I sent this timestamp?
This is one of the screenshots you sent to the detective, correct?
Yes.
Okay, and the times that are next to your messages would have been the time that you sent those messages.
Well, which incident of sending?
When she sent the actual text messages.
But you're inquiring about transmission to Detective Correa
No, when she sent those.
when they originally sent them to
Correct.
herself.
Yes.
Your question
No,
was
when
unclear.
when she sent the text, when you send a text message on an iPhone, you can swipe right to see the time that you personally sent that text
But the
message.
question inquired when, I think, what was the time at which you sent it? And I was inquiring whether you were talking about the sent a copy to yourself or whether it was the time when she transmitted it to Detective Correa, which was the subject of your sentence.
No,
Rephrase your question.
sure. Can you explain what the timestamps next to your text messages indicate?
Are you talking about the delivered part?
Yeah.
Well, it says that I left at 10:18. Is that what you're?
No, but so you see that there's a bunch of different times. 9:37 p.m. We'll start with that one. 9:37 p.m. You see that time?
Yes.
That was the time that you sent the text message 5 minutes away to Mr. Gutierrez's phone, correct?
Okay. Yes.
And then the same for the 9:43, the 9:44, 9:52, 10:08, 10:18.
Okay. Yes.
So you got there according to this text message at 9:43,
Okay.
43 minutes after you were supposed to be there.
Yeah.
And you then leave at 10:18, according to this.
Yes.
So you just started talking to a guy and you waited around for over 30 minutes.
Yes.
Why?
Well, just while I was waiting for him, I was on my Facebook, so I was just kind of like waiting. I don't know if he was in the shower. I don't know if he was getting ready. But like I said, I waited for him because I thought he was a very good guy. A guy that really expresses himself a lot about his job, his mother, and his kids. To me, that really says a lot about a person. He said he's been single for a very long time, and I said, well, so was I. So, I mean, okay, well, much can I say? I wanted to wait for this person.
Even though you were scared and nervous, you wanted to wait more than 30 minutes for someone to respond that you never met before.
Well, I've been single a very, very long time. I've been divorced since 2014. So meeting somebody was very nervous. For me, I was nervous. I was very nervous.
You also called Mr. Gutierrez that night as well, correct?
I was what?
Called Mr. Gutierrez?
I did.
Multiple times.
Yes, he did not answer. That's when I thought, well, maybe he's married. And I said, oh, it's time for me to go.
And then on direct, do you remember being asked the question by the state if at this time in your life you had anyone that would be jealous of you going to meet a man? Do you remember that question?
I'm sorry, can you say that again?
Do you remember being asked on direct the question that at this time on around May 17th, 2020, did you have anyone in your life that would have been jealous?
Yes.
And you remember saying no?
No.
But you did have an ex that was extremely jealous, correct?
My ex-husband? No, he already did his life. So what else can that be?
You had never, previous to this date, indicated that an individual that you had dated had, even though they were in custody, would still act jealous if you were talking to other men and would accuse you of talking to other men.
There's the
No.
relevance of this as well as the vagueness.
The state,
yes.
opened the door.
Well, it needs, for certain, it needs to be clarified.
Sure.
Rephrase your question.
Do you remember having an ex-partner who you were relatively scared of?
Yes.
And that person, you had thought at points, even if he was in custody, that he was keeping track of you, correct?
Yeah, that's, I mean, I don't know what you're asking me. I'm sorry.
He was a jealous ex.
Yes.
No further questions.
And
Any redirect?
Yeah, there's quite a few redirected. Just on that last point, we'll start there. Did that person have any idea you were coming down to Kenosha to meet Mr. Gutierrez Jr.?
No.
Mike, closer to you. Sure.
That person remarried, from my understanding. I have more children, so I don't know. Where is that question going?
I guess I'll follow up that. How many years ago was this jealous ex in your life?
2017, 18?
So several years prior to 2020?
Correct.
You had indicated on cross that you had seen a Facebook post in the evening hours of May 19th regarding Mr. Gutierrez Jr. Accurate?
Yes.
About him being missing?
Yes.
And upon hearing that information, what about that made you decide you needed to come down to tell what you knew about your supposed meetup with him the night of the 17th?
What made me come here?
Yes.
I'm a mother, and if anything happened to my son's 20 years old. If something happened to my son, I would need answers. And I feel like I put myself in his mom's shoes. That really hurt me. And I had to say something, step up and say something. If I have some clues or answers, I have to give this to the police. Why? Because it's the right thing to do.
And so you drove down then in the early morning hours of the 20th directly to the police station at roughly 7 a.m.?
Correct.
And you met with Detective Correa?
Correct.
And when you were meeting with Detective Correa, were you trying to show him some of these messages that are on your phone?
Yes.
And so when you're with him, are you taking some of these screenshots to kind of show him what you're talking about?
Yes. I was showing him everything.
I'm going to object to leading and have that be struck from the record.
The objection does sound leading to me.
What information did you want to provide to law enforcement on the 20th regarding your interactions with Mr. Gutierrez?
Everything. Messages from Facebook to the times that I talked to him, everything. I told him where I worked. I told him everything, because to me, it's like being forward and coming clean of who I am. There's nothing to really hide about.
And subsequent to meeting with Detective Correa, did he make any requests of you in terms of getting those messages to him?
I'm sorry, can you say that again?
Yeah, subsequent to actually meeting with Detective Correa in person, did he request that you email those messages to him?
Yes.
And so after leaving the Kenosha Police Department, did you then take the screenshots you sent to Detective Correa?
Yes.
And did you have more email conversations where he asked you follow-up questions regarding those messages?
Yes.
And was one of those specifically about timestamps of when messages were sent?
What do you mean, like from me and Rosalio, or timestamp from?
I'll rephrase. So there was some talk on cross about some of the screenshots being at 7:10 a.m. Do you remember that? 7:10 in the morning?
I know it was in the morning, but I don't remember exactly what time.
And then there were some that the screenshots seemingly implied they were about 8:03 a.m.
Yes.
And then some later ones that came at 2:44 p.m.
Yes.
In the original email to Detective Correa, which was shown to you with the date and time of May 20th at 8:26 a.m., did that email include the messages, the screenshots that you had from 7:10 and 8:03 a.m. that day?
Yes.
And subsequent to that, were there conversations via email with Detective Correa regarding some follow-up questions he had regarding your messages?
By email, no.
Did he request further screenshots of your messages, specifically with timestamps?
Yes.
So, where? handing you what's been previously marked as Defense 235. Can you just identify that this is a screenshot from 7:10 a.m. with messages starting 5 minutes away?
Yes.
And then the following page from Defenses 235, is that a screenshot of those same exact messages, but from 2:44 p.m. with the timestamps next to them?
Yes.
And after you had sent the original messages from 7:10 or 8:03, did Detective Correa ask you for ones with the actual time and date stamp of all of the messages being sent, not just the top one?
He asked me for all the messages, so I sent him everything that I had.
So back to Defense Exhibit 235. The 7:10 screenshot doesn't have all the times next to it. Is that accurate?
Yes.
And so you have an iPhone, is that true?
Correct.
And so in your familiarity with iPhones, when messages are sent in quick succession, is usually the timestamp only at the top of the message that are sent quickly? Or in a short succession, I guess I should say.
What do you mean by that?
So if you would look at messages on your phone, normally without doing anything else, would it appear the way it does at 7:10 a.m. where it just simply starts your messages at 9:37?
Objection leading.
Yes, it is.
Is this the normal way your phone would appear
Yes.
if you just took a screenshot?
Yes.
What extra step, if any, do you have to take on an iPhone to get additional times for date stamps next to it?
You have to hit the screen, push back. It's like extra work, I would say. So I would grab your phone, push back, and then snap it.
So you would have to take additional steps to do that.
Correct.
And so if you had originally sent the screenshots to Detective Correa, would it have been a request from him or somebody else for you to do that extra step?
What do you mean? Like if it would be from him,
When you took the initial ones at 7:10 and 8:03 a.m., you didn't take that extra step.
no, I didn't.
Okay. Subsequent to that, you took that extra step.
Right.
Was that a request that law enforcement made of you to get the exact times your messages were
Yes.
sent to you?
He just said, make sure you get the times, and I must have sent that one first, and then just kind of start working through the other ones.
So there were multiple communications and sending of messages to Detective Correa as part of this case.
Right. Yes.
Now, you were asked when these screenshots would have then been taken and sent. And so in looking at Defense Exhibit 235, this first email you have with Detective Correa, which you testified to, comes through at what time?
8:26.
a.m. on the 20th? So if you had to take additional steps to do that extra piece for 2:44 p.m., would that message have to have come through to the detective after May 20th at 8:26 a.m.?
Yes.
I'm going to show you that map again of the Wood Creek Apartments. The night of May 17th, which building specifically did your whatever map program you use take you to where you thought you'd be meeting Mr. Gutierrez Jr.? Which building on there? If you'd like to get up on pro.
I'm going to object as far as it's kind of argumentative and testimonial in that this witness at length on cross was not able to definitively say which building she was at on May 17th, 2020.
Maybe it was the way you asked the question. I don't know. I'm not suggesting that's the correct answer. I'm just saying I don't know. Witness can speak for herself. You can ask on recross.
So on May 17th, that's the building your GPS took you to?
Yeah.
And when you testified on cross regarding meeting up with myself and District Attorney Gravely, what building did your GPS take you to on that day? So that same building? And you'd indicated that there was a little bit of surprise from the District Attorney's office in terms of the fact that that was the building you were at?
Objection calls for hearsay and speculation.
Your Honor, they opened the door to it and she testified to it.
Well,
I'll
think
withdraw my objection. I'll withdraw my objection.
You know what, I'll withdraw the question. So, on both May 17th and in March, when you met with the District Attorney's office, that's the same building that you were taken to?
keep using the term
Objection
taken
meeting.
to. Directed to, maybe?
She's also leading judge.
Well, she's just repeating what she already said.
Then asked and answered.
I'll move on.
Bless you.
I have no further questions, thank you.
Any question?
Yes. Back to the GPS or the map application that you were using. You were using a different map application on May 17th versus the time that you met with the district attorney's office, correct?
Yes.
And when you met with the district attorney's office, when you met with Mike Gravely, where did he meet you? If you could point out on the map, where did he meet you when you met with him?
Here, and I believe he was somewhere else, and he was asking me, where are you? And I told him I'm right at the same location where I was at. From the date that I was supposed to meet Rosalio, and walking from this angle, and I was already parked here waiting for him.
So previously you told law enforcement that you were in front of Mr. Gutierrez's apartment, correct?
Yes.
And then it's only after you met with the district attorney, Michael Gravely, that you are now saying you were in a different location.
There was three different.
It's a yes or no answer.
There was three.
No. I don't allow witnesses, lawyers to restrict witnesses like that. Go ahead, ma'am.
There was 3 different times I moved. When I arrived, in the beginning I said...
Which date?
I'm sorry?
Which date?
May 17th.
Okay, go ahead.
2020. I arrived and I parked over here and I waited for a couple of minutes and then I parked by the dumpsters.
This is non-responsive to my question.
Go ahead with your answer.
And after I waited a few minutes, I parked right in front of the building.
I'm going to ask you the same question again. You can sit down. You previously said May 17th, on May 20th and May 22nd, when you talked to law enforcement, when you talked to the detectives, you told them you were in front of Mr. Gutierrez's apartment. You then, when meeting with the district attorney, Mike Gravely, said you were in front of a different building, correct?
That's the only building that I was at when I was supposed to meet Rosalio. I don't know where does he really live. I know that's the building that old maps guided me to.
Well, when he texted you, he gave you his apartment building number, right? He gave you his apartment number, 1B, correct? And when you had that information, you then told law enforcement you were at his apartment.
I just pointed out the building that I'm thinking that's where he lived.
I had asked you, the state had asked you about the meeting with the district attorney's office just now. You had said that attorney Mike Gravely had called you. Were you expecting that phone call?
From the DA?
Correct.
No, I was looking around like, where is he? And I was looking for the other lady that was with him. And I was standing in that same building that I just pointed out, and I didn't see them. So I was just waiting and waiting. Finally, they called me and they said, where are you? I said, I'm right in front of the building.
So I'm sorry. The phone call you received from attorney Gravely asking you to meet him at the scene.
Yes.
Were you expecting that phone call?
What phone call? From him?
Yes.
No, I was expecting to meet him at that same building.
But, okay, you keep saying you're expecting to meet him at that building, but prior to your expectations of meeting him at that building, were you expecting the first phone call where he called you to tell you to meet him at Wood Creek Apartments?
No, I wasn't expecting that. So we were here and we met up here at the DA office. We talked about it and he says, we're going to meet you over there and I'll see you shortly. I said, okay, then I'm going to head over there right now.
So prior to you going to the scene of the crime, you had met with attorney Gravely at his office?
Yes.
And what did you talk about in that meeting?
To basically that I'm gonna be subpoenaed and that I have to come in court and testify. That's it.
And
As a witness. That's like, and I asked him questions like, well, did we hear anything about Rosalio? What happened? What's going on? Nothing. He didn't say nothing. He just said be prepared.
well,
It was very briefly. We weren't here very long. He just met up here, just told me we're going to go back to the scene and you're going to explain to me, the lady who was there, and you're going to tell us what exactly, where were you parked?
So he told you that he needed you to tell him where you were
Yes.
because something wasn't adding up, correct?
He didn't say that, nothing. He didn't say something wasn't adding up. He just said, we're just going to go back and you can explain a little more detailed where were you parked.
But he did tell you that your timeline
Yes.
didn't add up to the evidence.
No, he didn't say it didn't add up. He just said, we just need to know what time, how long were you at that, where were you parked exactly?
But he told you there was an issue with your timeline.
I'm going to object to ask an answer. She's used even timeline multiple times, and she said that's not what he said to her.
This shall exhaust the line of inquiry. Go ahead. Did you understand the question?
Yes. And he didn't say something that did not add up. He just said, We just need to go there and kind of give us a little detailed information. Where were you parked?
That was my second to last question. My last question was, there was some issue that he had with the timeline, and that's why he then wanted to take you to the scene.
Well, she said he had not said that. Now your question seems to be inquiring what was in Mr. Gravely's mind, which would be speculation for this witness.
I'll move on. So who then called you to meet? How did you know to come to the district attorney's office to meet prior to you going to the scene?
One of the ladies, she works at the DA office. I'm sorry. Is she an advocate, or I'm not sure. What was her name? Heather?
Sorry, are you asking the state official?
I don't know. I'm trying to remember one of the ladies that called me to inform me to meet with the DA.
So you hadn't called the district attorney's office?
No, they called me to tell me to come to the office, and we were going to discuss a little bit on what was going to happen. I was going to get subpoenaed, and I was going to, come to a court date. That's it.
Was it Attorney Gravely's idea to take you to the scene of the crime?
I don't know if it was his idea or not. I just was told to go to the scene.
But it wasn't your idea?
No.
You didn't offer to go there?
No.
And then when you were at the scene with Attorney Gravely,
Nothing. He asked me, where were you parked? How long were you here? What time did you move your vehicle? Like those 3 times that I moved my vehicle, where was I parked? And he asked me in the beginning, like, where are you? And I said, I'm at the location at that building. He says, are you sure? And I said, yes, I'm at this building. This is where Google and Apple guided me to go. And I was told that that's not the building.
Mike, Attorney Gravely told you that's not the building, correct?
My understanding, that's how I took it. That's not the building.
So just, if you can answer the question directly.
What do you mean?
No.
Oh.
My question, sorry. You're fine. The district attorney told you when you were there, that's not Mr. Gutierrez's apartment.
Right. Yes.
And then, did he take you to Mr. Gutierrez's apartment?
No.
So after you take Google Maps to that location at the request of Attorney Gravely, Attorney Gravely says, that's not it, and that was everything?
That's it.
Nothing further.
Any question?
Two questions. When you gave your first statement to law enforcement back on May 20th, it was memorialized on the 22nd, and you said you were in front of Mr. Gutierrez's apartment, did you believe that the apartment you pointed out to us twice was Mr. Gutierrez's apartment?
Yes.
And knowing what you know today, do you have any guess which of those buildings on there is actually his real apartment?
I don't know.
I have no further questions.
Any questions?
No.
Thank you. You may step down.
Thank you.
Let's break, folks. And let me ask that you return at 1:30. And please don't read, watch, or listen to any account of the trial, and don't discuss the case with anyone, even members of your household or fellow jurors. Any questions? Thank you. Everybody here, I guess so. Go ahead.
Judge Aileen Noll has 0 priors. Aileen Noll has 0 priors. Neridia Macias had no priors. I don't think we did that before she testified. Michael Campbell has no priors. Brandon Hendrickson has a 2010 disorderly conduct. We are suggesting that's outside the 10-year rule, which would at least be one consideration from the court, knowing it's a disorderly conduct. My understanding is defense wishes to make an argument regarding that. Do you want to do that before I go on?
Well, it's not a 10-year rule in Wisconsin. Wisconsin is explicitly, well, not explicitly, but has, by non-adoption, has rejected that 10-year bright line. But it's a DC more than 10 years old.
The DC from 13 years ago, and I did not mean to imply that we had a mandatory rule. I just indicated it could, perhaps was a factor.
What's up from the defense?
Judge, this witness is an individual that had accompanied Mr. Campbell to Mr. Anderson's home. I think that given his involvement in this case, that his prior conviction, that the fact that he has a prior conviction should be heard by the jury.
Do we know anything about the nature of the DC?
No, but I'm only aware that it's supposed to go to credibility. I'm not aware that the court would typically make a decision about impeachment based on a prior for any other reason other than credibility.
Well, I do agree with you there.
Okay.
And in this situation, there is some evidence that Mr. Hendrickson had a gun with him at the time that he did go to Mr. Anderson's home. It's my understanding that he will probably testify contrary to that. And I think it's important that his conviction, the fact that he has a conviction, obviously we won't go into what it is, that should be heard by the jury, especially since we don't know what he's going to say as far as why he accompanied Mr. Anderson, what he had, and what he was planning on doing had he confronted Mr. Anderson.
I'm unaware of any evidence that he had a gun. If counsel is presenting evidence he had a gun or wishes to impeach with evidence he had a gun, I'd certainly ask them to share that with the court, but I'm unaware of any evidence he had a gun and do not believe that's relevant in terms of this analysis.
Well, first off, I do agree with the point made by Mr. Gravely that this is strictly for credibility, and the role of the defendant with respect to any events would ordinarily not be a factor in the determination about credibility. And of course, this is all dependent upon whether he testifies anyway. In addition, I don't know the fact that he may or may not have had a firearm, if that is shown or suggested. I don't know whether carrying of a firearm would have been lawful. I think that the best approach is look at it strictly from its usage for credibility purposes, and a 10-year-old DC without intervening events, criminal events since then, I would ordinarily not admit. So, unless you have something else, I'm going to say that's not grounds for impeachment.
No, nothing further.
Okay.
Okay, there's a woman named Erica Saylor, Saylor, who we intend to call as a witness in this case. She has a 2005 bail jumping conviction, so that would be 18 years from now, 15 years from the date of this offense. And we, again, do not believe that should be counted, but counsel has indicated they wish to make argument on that as well. I'm aware of the circumstances of that bail jumping if the court wishes me to share those.
The defense is withdrawing their prior objection to including that.
The request that it be included is withdrawn, okay?
Correct.
Then that settles that.
And then we have a witness, Marquand Washington, and the parties, I believe, have come to an agreement that he has 6 prior convictions.
Is he in agreement with that?
Mr. Washington, we have reviewed CCAP and are aware from CCAP of his 6 priors. We have not shared that with him specifically, but we're aware from reviewing CCAP, they're all Racine County convictions, so they're all acceptable convictions for us.
Well, the critical point is he can't come up here without having, advance notice of.
I will certainly consult him and let him know.
Impeachable number. And of course, the question should be phrased for a purist like me. Some of my colleagues are all right with having witnesses.
Judge, is your microphone on? Tough time here.
Oh, it is. Yeah, I don't, but anyway. I go to these conferences, and some of my colleagues think it's quite all right to have a person who's got 25 priors to get instructed that there's only 3, and after having taken an oath to tell the truth, testify to that. I don't believe that. So it's all in how the question gets asked, and this is where leading questions are so good. Whatever your number is, if you're both agreed on it, and it is indeed sustained by his record, just ask him, you have 6 prior convictions, no? And
I will.
yeah, and you can tell him if he answers that way, he won't have to relive the sins of his past life.
I will instruct him accordingly. So those are the priors that we wanted to cover at this point, and so I believe we're ready if the court is ready.
I'm ready. Ready?
One moment, Judge. Judge, I don't know who the state's calling next, but if it is Michael Campbell, then there is something that the defense wants to be heard on.
It's not.
It's not? Okay.
But
If it's going to be soon, let's do it now before we bring the jury down and then have to send them out again. So what's going on? Is he going to be hearing, or
he'll
are we
be in
going to
the
hear
first
from today?
3 witnesses this afternoon.
Huh?
He'll be in the first 3 witnesses this afternoon, Your Honor.
What's up with Mr. Campbell?
Sure. The court's well aware that Mr. Campbell was the target of a Denny motion filed by the defense.
Correct.
So we do anticipate asking him some questions as it relates to his involvement in this case. And we just wanted to make a preview of that. So if the state would have any objection or try to assert that we're attempting to introduce Denny evidence as it relates to Mr. Campbell, that we can be sure that the introduction of that evidence is solely for the purpose of establishing a fact of the events that occurred around May 17th to May 19th, 2020, and that anything that would be offered that could imply that any sort of involvement is just being offered for further questioning with detectives about the police investigation.
So far, I don't know what we're talking about.
So specifically, what we intend on diving into with Mr. Campbell are the following. The first would be him being present at Mr. Gutierrez's apartment on May 17th, 2020. That he had gone to Mr. Anderson's home with his friend, that he had interjected himself in the investigation, and that he had items in a van that he had allegedly taken to Pheasant Run Security Landfill, and also his whereabouts on May 18th, 2020.
So we object to
all of which wasn't followed up on.
So we object to anything about items in a van on the 18th, but certainly proximity to the apartment appears to me to be something that would be appropriately asked. Where he was on the 18th, I guess that's fine if the court finds that a relevant question in the context of everything else that's going on. I guess so. I guess I'd ask the court to see where we're at when that comes up, but I appreciate being on notice about it. What was the last one? I apologize. 18th?
The 18th.
What was in the van?
What was in the van? Pheasant Run Hill Landfill. No, what was in the van? I don't know. I didn't say that.
Oh, what was in?
Pheasant Run Security Landfill.
Security?
Landfill. That's just the actual full name of it. Most people, yeah, I don't know why, but that's what Waste Management tells me.
Yeah, what he dumped at a landfill, unless there is some specific additional information that wasn't shared at Denny, in the Denny motion, I think is irrelevant. Again, I would suggest to the court that let's see what happens about his whereabouts on the 18th, if that would be relevant. We know that that I think his being at the home on the 17th in that early morning hour time period is an acceptable question, and I think what he did on the 19th in terms of going to the scene and also going to the house of the defendant is relevant.
Okay. So, I don't have to rule on anything right now,
No,
but we know what we're up against. All right. Anything else right now?
Not from the state.
Okay.
I have no idea. Hello?
Would you come down, please?
Okay.
Thank you. Good afternoon, everyone. And let's continue with the state's case.
State calls Officer Shawn Giovanni to the stand.
And Judge, as the officer's coming out, I would just want to move into evidence defense exhibit 236. That was the printout of text string between the last witness that was testified to.
Any objection?
None.
Received. And you can tell me what testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated.
Officer, could you please state your name for the record and spell it?
Officer Shawn Giovanni, Giovanni.
And how are you currently employed?
With City of Kenosha Police Department, third shift patrol.
And were you employed in such a capacity on May 19th of 2020 at roughly 10:43 p.m.?
Yes, I was.
And on that day, were you also working third shift patrol?
I was.
And would 10:43 p.m. be shortly after you got on duty that night?
Yes.
And as part of your duties, do you have any sort of special training that leads you to have a slightly different role at crime scenes than potentially other patrol officers?
Yes, I do.
And what is that title?
Evidence technician.
And back on May 19th of 2020, were you also an evidence technician?
Yes, I was.
And when you got to work that day, were you dispatched to a search warrant occurring at 6813 West Highland Road in Mequon?
Yes.
And did you respond to that location to perform evidence technician duties?
Yes, I did.
What can you tell us generally about the residence itself after you had arrived?
About the layout or anything?
Yes.
You're asking?
Yep, what do you remember?
It was a two-story house, single-family home with a basement. I remember when I walked in that the walls, as I described, looked like it was on renovation because all studs were exposed, and there was debris and clutter throughout the lower level.
I'm going to show you some pictures from State's Exhibit 1, starting with photo number 265. If you want to direct your attention to the screen. The TV flicked on and then it. Thank you, Detective. Now, obviously, you were there in the evening hours. Is that accurate?
That is correct.
But is this, in general, what it looked like when you were there as an evidence tech on the night of the 19th?
Yes, it was.
And what area are we looking at this residence, if you know?
This looks like the back porch area when you first walk into the residence.
I'm going to show you picture number 266. What are we looking at here?
This is the lower level of the house.
And does this picture depict some of the exposed studs and under renovation feel of the home?
Yes, it does.
And does this appear to be an accurate representation of what it looked like the night you were there to help in the search?
Yes.
Show you number 267. What is this vantage point?
Different area of the lower level.
Towards the right side of this exhibit, is there a couch and a TV?
Yes, there is.
And is there also an ottoman there?
Correct.
Would you characterize that as the living room?
Yeah.
Right. Showing you 268. What is the general look of this picture?
That's where you come in from the back door off the porch.
And was this the general condition of it when you assisted in the search on the night of the 19th?
Yes, it is.
Picture number 270. What is this a picture of?
Area where the couch is on the lower level.
And in your role as an evidence technician, were there other officers and detectives assisting in the search?
Yes, there was.
And if they would locate something that they thought had evidentiary value, was it then your job to photograph and collect it?
Yes, it is.
And were you also participating in the search at the same time?
Yes.
I'm going to show you. I'm going to ask, in this picture, you had talked about a ottoman. Would you mind getting out of your seat and just pointing out where that ottoman is in this picture?
Sure.
And you can grab a seat. And was there anything of evidentiary value that was discovered in that ottoman, if you know?
Yes, there is a, there is a bag with a large sum of money in it.
Okay. I'm going to show you what's been marked as photograph number 296. What is this a picture of?
The bag with the large amount of currency.
And when you say a large amount of currency, was one of the jobs that you assisted in counting that currency?
Yes, it was.
And what, if you recall, was the total amount of money inside that bag?
About $47,700 some odd dollars. I don't remember the exact amount, but almost $48,000.
And what kind of bag was it in, if you recall?
It was in a bank bag, I believe.
Were there other items of evidentiary value that were located by other officers on the main floor of the residence?
Yes.
And what were some of those items?
There was some drug paraphernalia and I believe a camera.
When you say drug paraphernalia, what do you mean?
Large amount of marijuana, a couple of different bags. There was a container with a grinder in it, marijuana grinder with appeared to be marijuana seeds in it.
I'm showing you it's been marked as number 295. Can you tell me what that is?
That's the
I'm
container.
going to object to the relevancy of this evidence.
So, Judge, this again, door was open to this in the Christine Remsburg testimony. We previously argued about this, and this is our recitation of that evidence that we previewed for the court.
Objections overruled.
What is this? What is inside this container, if you know?
Judge, sorry, I am going to object again and make a record that their questioning on the cross-examination of Ms. Remsburg had to deal with a grow operation in the residence with plants. So I don't believe that any of this evidence is relevant
Gibby?
or relate.
Overruled.
Officer, what is this?
This is the container that had the metal marijuana grinder on it and apparent marijuana seeds.
And you indicated marijuana seeds. Is that what we're looking at
He
here?
said apparent marijuana seeds.
I couldn't hear him. I apologize.
I don't know, you don't have to apologize. It's, should have spent more money on the system.
And there's a couple of, I think, 5 different, what looks like to be canisters in there with or jars of some kind. Is that accurate?
Correct.
And is there some sort of handwriting on each of those jars?
There's different names on each jar.
I'm going to show you. Picture number 307. Can you tell me what this is?
That's one of the bags that had marijuana in it.
And was that also located on that lower level?
Yes, it was.
Then I'm going to show you picture number 308. Can you tell me what that is?
Looks to be a mushroom.
I'm going to object as far as relevance to mushrooms.
Same thing, Judge. If you have a marijuana grow and you are also manufacturing and putting together mushrooms, again, Ms. Christine Remsburg's ability identified on cross to be able to tell whether the defendant was perhaps hiding anything from her or concealing some of his activity is directly relevant.
To Judge, to that point, the state didn't ask her about anything dealing with a mushroom grower operation, and one doesn't mean the other exists.
It's exactly the same concept, Judge.
The objection's overruled. You can answer if he hasn't already.
I'm sorry, what was this object that's in this picture depicted?
Appears to be a mushroom.
Now, were you specifically yourself responsible for helping to search the stairway leading up to the second floor of the residence and the second floor itself?
Yes, I was.
And on that stairway, do you recall, on the second floor, do you recall finding a bedroom that you were able to attribute to someone?
Yes, I did.
And how were you able to attribute that bedroom to a specific person?
I found a Wisconsin driver's license in there.
Was there anything else located in that bedroom that you thought had evidentiary value?
Yes.
And what were those items, the best you can recall?
There was a laptop computer, a couple hard drives for a computer, and I think 3 computer towers.
I'm going to show you what's been marked as picture number 303. Is that some of the things that you found in that bedroom?
That is correct.
And there's a box that's sitting on top of the yellow legal pad. Can you tell us what was in that box?
Mini GPS system.
And you had indicated that you had recovered a laptop. Is that correct?
Correct.
And you what's previously been marked as State's Exhibit 114. Based on the packaging alone, can you indicate to us what this is and if this was a laptop that you recovered that night?
Yes.
And how do you know that that's a laptop you recovered in the bedroom of Mr. Anderson?
Well, feels like a laptop in here without looking.
Are there information on the tags itself that are put on the front of things that illustrate what is contained inside of an evidence package?
Yes.
And what does this one say?
MSI laptop with charger.
And is that something you recovered from Mr. Anderson's room that night?
That is correct.
Can I just grab that from you? Your Honor, I would state Exhibit 114 as evidence.
Objection?
No objection.
Received.
Then I'm directing your attention back down to the first floor of the residence. I'm going to show you picture number 297. Tell me if you recognize what is in this picture.
Yes, those look like seats out of a vehicle.
And were those located in the residence on the night you helped search?
They were.
No further questions. Thank you.
Cross-examine?
Yes, if I can just have a brief moment, I have to confer with Detective Correa. I'm going to show you what's been previously marked as Defense Exhibit 154. So, you were responsible for collecting evidence from Mr. Anderson's property?
Correct.
And so, this grouping of photos here, you collected these papers, correct?
Yes.
Okay. And do you remember how you logged them all together?
Not particularly, no.
Okay. I'm going to hand you what's been marked as Defense Exhibit 241. Before you open it, if you could just read the description on that exhibit.
Says court paperwork, other miscellaneous paper.
Okay, if you'd be so kind to open it. And could you briefly just go through those papers and tell me if you find a receipt?
You're talking like a shopping receipt.
I'm sorry, did you answer him, counsel? Ken?
Are there any receipts in there?
No, not like a shopping receipt.
Judge, may I approach the witness?
In the meantime, can we take a look at this receipt? This exhibit wasn't shown to us, so can we inspect that?
Yeah.
So there was no receipt in that exhibit for tax returns, correct?
Not that I saw.
So in this picture, and if you need to take it off the Elmo to look at it closer up, do you see a receipt for an item?
Objection. How do we know this is the same as the exhibit we just saw?
Well,
Or are you
the
indicating that?
exhibit did not, I asked him if the exhibit had any receipts and he said no.
Right? So will this picture be relevant? Objection, relevance. Why would
We
this
can have
picture
a
of the
discussion
receipt?
of this outside of the presence of the jury. This
What is that photograph? What is that depict as a general, the entirety of it?
Sure, as the officer already testified to, that these are items that he got together from Mr. Anderson's home. Those were logged as evidence, as miscellaneous paperwork, which was supposed to be item 19. These papers are not in Exhibit 19 or item 19. So now I only have the picture to rely off of.
So what is your objection?
My objection is that we just opened this and it doesn't have those items. So why this picture purports to be the miscellaneous paperwork? That paperwork is not in this item. So they're not one and the same.
Well,
I'm not asking about that exhibit anymore.
you can cover it on your redirect. What is this photograph depict again, officer?
Seems like paperwork that was photographed at the residence.
And where did the paperwork then go?
So all the paperwork that I collected, I plugged in evidence. There might have been some paperwork that wasn't actually collected as evidence, but just photographed. So,
Yeah, this is why I asked for a sidebar, because I had viewed those. Yeah,
Get in you.
thank you.
I couldn't hear the court. I apologize.
I said she could continue.
Thank you.
And I can hand this to you so you can more clearly see it, perhaps. But was there a receipt? Do you want me to hand it to you?
yes, please.
Do you see any sort of receipts in that photograph?
No.
Either. You don't see a.
Oh, I'm sorry, in the photograph, yes.
Okay. And could you point those out, and perhaps if you could put this back on here so you can show the jury? You could just get the pointer that the judge has and go up to the TV.
Sure.
Thank you.
What would you like me to point out again?
The receipts that you have viewed. Okay, and that's a Walmart receipt? Okay, do you see another receipt that's in the upper right-hand corner of the photograph? Okay, and did you log that receipt that we see on the top right photograph separately?
So this is a table in our evidence room.
Table and where?
Officer?
Oh, sorry. Thank you. This is a table in our evidence room. And when I log evidence, I put paper down so there's no cross-examination. So if this is in the evidence room, I did log it.
Okay.
Yeah, counsel, we just have a moment for your time. Just have a moment for your time.
Judge, may I continue?
Go ahead.
Thank you. So the receipt on the upper hand corner, you can come back and sit down, officer. Thank you. Obviously, you'd agree that the picture up on the elbow looks a little blurry.
Yes.
So it's hard to make out what exactly that receipt says or the paper underneath the receipt says.
That is correct.
And if you wanted to look at the exhibit itself, is it any clearer?
Judge, again, I'm going
And
to
this
object. I apologize, counsel. It is, I don't believe that counsel is actually purporting that the officer actually processed the evidence in the picture that she is showing this witness, like
Well, you're using the word process.
that he would be the custodian or the person who in some way dealt with this evidence. So I believe this is not a witness who is specifically familiar with this evidence.
I think his prior testimony was that he did log this evidence.
Well, you're using terms from the legal system like process and log. Have you ever seen this before? Right here.
Thank you. Yeah, I don't know. Okay. So because it was a long day, I did have assistance with logging the evidence. I don't remember every document that I put in there, but like I said, if it's on this table, we logged it. I did have other officers helping me just because of the currency. We have to have multiple officers as policy to verify count. So.
Okay. And this has already been accepted into evidence. So when you looked at the document, this receipt and paperwork that was on the upper right-hand side, when you had looked at it, were you able to make out what the writing says?
On that paper, no.
Even when you looked at it closer up?
I couldn't.
Okay. The state had shown you an exhibit that was a photo taken from a desk in Mr. Anderson's home. On those were some items. Do you remember?
Yes, the driver's license.
Yeah, the
Yes.
box. Showing you what's.
I'm showing us the picture. I think this is a new picture you have not shown us previously. You can do that before you.
Okay, showing you what's been marked as Defense Exhibit 239. Is this a more close-up, or I guess strike that. This was a picture of that box that you had taken from the desk, and this is the picture taken back at the police department, correct?
Yes, sir.
Okay, and when you took the picture of this device, the device was in the packaging?
So I personally, like as said in my report, I didn't do the photographing on this scene. Officer McKee did. I was the one collecting and documenting while he was photographing. So these photographs at the PD, these were all done by a different officer.
Okay, but this is the same item that you viewed on the desk?
Yes.
Okay, I'm showing you what's been marked as Defense Exhibit 240. Is this a side profile of that same box?
It could be.
Okay, you just don't know.
Not. It's been a while since I looked at it. Yes.
Okay, you'd have to see the entire box.
Yes.
Okay. So you arrived at Mr. Anderson's house on May 19th, 2020?
That is correct.
And that was just as the state had noted to collect evidence that other officers had pointed out.
That's correct.
And when you do that, it's oftentimes that the evidence that you take photos of or take and process from the scene are not in the original location that they were when the first responding officers would have arrived.
It does happen.
Judge, Detective Correa has kindly gone to the police department to get one of the physical exhibits that I do intend on crossing this witness on. So I don't have any further questions opposed to the questions that will be asked when we have that exhibit here in the courtroom.
I think we have a few questions.
Do you have a few redirect?
Oh, Vinny's here.
Oh,
Defense Exhibit 242. Before you open it, if you could just,
Before you show the exhibit, I just want to get this.
ready? Yep. All right. Defense Exhibit 242. Before you open it, and I will ask that you open it, and did you want a new pair of gloves?
Yeah, I don't
Yeah.
like to cross-contaminate.
Yeah. If you could just, I'll get you new gloves, and then if you could just read what this is.
Sure.
Thank you.
Says miscellaneous paperwork.
Okay, and if you'd be so kind to open that. Here you go.
Thank you.
Officer, as you're opening it, if you could just, you can look through the documents, and if you could determine whether the items that we can see in Defense Exhibit 154 on the upper right-hand side are in that exhibit. Yeah, of course. Did you find something?
I found a couple of things.
Okay. So first thing, did you find the receipt that was in the upper right-hand quadrant?
Not yet. I
Oh, okay.
found a small white one.
Okay, that's fine. I'm just, once you get the documents, let me know.
Okay.
Oh, perfect. So I'm gonna put it up on here. Okay, so you'd agree that this document appears to be the same document that is in Defense Exhibit 154 in the upper right-hand quadrant?
Yes.
Okay. And this appears to be, and you can take it and look through it, but it appears to be some sort of tax return.
That's what it looks like to me.
Okay. And this receipt, can you read the date on that receipt?
It's 5/18/2020.
Okay, and that it's a receipt in the amount of $243 for this tax return?
Correct.
Okay, is there a reason this wasn't processed separately from the group of other paper that you received?
No rhyme or reason, no.
Okay. Put this here. Now, in this picture, do you see a yellow piece of paper that says memo anywhere?
I see a corner of a yellow page.
Okay, and did you see any yellow pages in that pile of documents?
Yep.
Okay,
Right in front of
can
me.
you hand it to me, please? Okay. As far as I can zoom out. So this memo says we will hold your tax return for 24 hours to give you a chance to review it, correct?
Yes.
And then on the bottom it says DMA accounting.
Correct.
All right. With this other document, which was the tax return, it was completed by DNM accounting. According to what's on the paper.
I don't know how he would know whether.
Sure, I'll rephrase it. I'll rephrase the question. What does this piece of paper state at the bottom?
DNM Accounting Services.
Okay. And then is there a note, a little sticky note on the top of the memo?
Yes.
And could you read what it says?
We'll stop in today, 5/18/324 p.m. call.
This call or collect? Do you need to look at it closer?
Oh. Collect, yes. Looked like call from the system.
I'm sorry, did it say 2:24 p.m.? Is that what you had? Is that what you read?
You read 324.
Thank you. 3:24. Thank you. I see that back.
That was what they did. And so all of these, the two paperworks that I just went through with you, this yellow, mustardy memo, and this receipt with a tax return, and all these other papers were all included in item number 21, which was Defense Exhibit 242.
Correct.
And that was processed?
Yeah, it's all packaged together. That's correct.
Okay. So I want to go through the other things that were in there. Yeah, sorry, officer. Thank you. It's a lot here.
You have a picture exhibits all along while you do that.
Sure. Did you want to look at these?
Well, I don't have gloves on, but
Do you want to put gloves on?
I'll look at them with you. So why don't you go through them once with, so that I don't have to put gloves on. Just page turn quickly.
This is.
back 40 years.
I'm gonna ask you to go through every single piece of paper. But I do want to establish everything that was in item number 21, Defense Exhibit 242, okay?
Okay.
So
Can I hand this back to you?
we're willing to stipulate that the document, for purposes of this exhibit, that the documents in that pile were all processed by this officer. So they are true and accurate items that were processed by him. That assists.
That would.
If
And
that saves time, rather than having him list documents that obviously he didn't specifically, explore.
that's fine if you stipulate to the admittance of it as well.
To the what?
To the admittance?
Yes. Yes.
That's fine. That will be sufficient. So I don't need you to go through all of them.
Okay.
But I do want to go through just one more thing about this item. You had read what it said on the bottom as far as the name. Could you read the address as well?
North 96 West 20, 221 County Line Road, Mountain Falls, Wisconsin.
Officer, I'm sorry, we're having trouble hearing you. This mic is a problem for us. Did you read the address, including Menominee Falls? Is that what you just did?
That is correct.
Thank you.
Sorry.
That's fine. Do you have that back again?
Yeah.
Okay. And so all of this in this bag, the state stipulating to it, Judge, I'd ask that Defense Exhibit 242 be moved into evidence.
Well, there's typically that what is contained in that evidence container paper bag within the document. Within the bag.
Correct. They're stipulating that everything that was pulled out was included in item 21, which is Defense Exhibit 242, and that these items were processed by this officer.
You agree with both those things?
Right. Thank you. Detective. Prefer that you put everything back? You just put everything that was in the bag back in, and then the detective Rosario will, and there's that little receipt there. Thank you.
Redirect. No question. Thank you. Mister.
Do you solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Hendrickson, state your first and your last name, spell both your names for the record.
Brandon Hendrickson, BrandonHendrickson.
How old are you?
42.
And what do you do for a living?
I work at a medical facility.
And in general, what city or area do you live in now?
Walking.
And where were you raised?
Kenosha.
And did you, at some point in your life, know a person who you knew to be named Rosario Gutierrez?
Yes.
In very general terms, how did you know him?
I met him in high school.
And how would you describe your relationship with him back in the time period of May of 2020?
Same it's been the whole time I've met him. Great friendship.
Friends?
Yeah, absolutely. Brothers, you know.
High school friends?
Absolutely.
Okay. Continued on through 2020?
Yes.
If you would estimate how many times in the time period of January 2020 through May of 2020, what would be your rough estimate at how many times you either saw Rosalio Gutierrez in person or heard from him in some fashion?
Well, I'd only come down to Kenosha once in a while, so, I mean, I'd probably see him at least once or twice a month.
Okay. And what about hearing from him?
About the same.
All right. And since May 17th, 2020, how many times have you seen Rosalio Gutierrez in person?
0.
And since May 17th of 2020, how many times have you heard from him in any of the ways he used to be in touch with you?
0.
Now, on May 19th, 2020, were you located in the Kenosha area?
Yes.
And did you at some point come to hear something that caused you some concern?
Yes.
And where were you located when you first heard it?
I was getting a tattoo.
Do you remember in general where?
Sheridan Road in like 46th Street, I believe.
Okay. And did you just happen to be in Kenosha to do that, or was that
It was planned.
Okay. And if you know, again, only if you know, when was the last time you had seen Rosalio Gutierrez prior to the moment you're in Kenosha getting that tattoo, in general?
May 7th.
Okay. And so on May 19th, about what time do you hear from someone approximately causing you concern?
I'd say mid-afternoon.
Okay. And if you recall, who did you hear from that caused you concern?
I was scrolling Facebook and I seen Michael Campbell post the post. If anyone's seen or heard of him from, we call him Junior, get a hold of me or get a hold of police, Kenosha Police Department.
So if you refer to someone as Junior during this testimony, you're speaking about Rosalio Gutierrez?
Yes.
So when you saw that Facebook post, what did you do next?
Text Mike, or I believe I called him, one of the two.
Okay.
I was like, what's going on? And basically, from what I remember, he told me that, he was just
I don't object that the answer is calling for hearsay.
Yeah, you don't have to tell me what he said specifically, just tell me what you did next.
I finished getting my tattoo and I went to Mike's house.
And you already knew where Mike lived?
Yes.
So when you, did you go right there as best you remember?
Yes.
Okay. When you got to Mike's house, that's Michael Campbell?
Yes.
And how do you know Michael Campbell?
Since elementary school.
And do you know him to have some relationship with Rosalio Gutierrez back in May of 2020?
Yes.
And based on your knowledge of them, who were they to each other?
Well, friends first, but they were working together.
Okay. And so when you arrived at Michael Campbell's home, about what time, again, I'm not asking you exactly, but about what time would you expect it was?
Around 4:30 in the afternoon, maybe.
Okay. And who was at Michael Campbell's home when you got there that you remember?
It was Michael Campbell and Erica Saylor.
Now, this was a couple years ago, right? And was it sort of shocking, the circumstances, etc.?
Yeah, that's your leading, absolutely. Judge.
Well, based upon what's already come in the objection.
And at the time you arrived there, what was happening there at Michael Campbell's home?
I walked in, I asked Michael what was going on, and then what I recall next was Erica stating, I have his address.
Objection, hearsay.
And Judge, I'm going to indicate that it is for purposes of what happens next. Ms. Erica Saylor is going to testify in this case, and this is not specifically for the truth of it. It's so that the jury can follow with a coherent narrative about why people did what when.
And I'm hostile to that explanation because it holds a lot of hearsay in with it, and so the objection is sustained.
After you heard information, whatever that information, so I'm not asking what was said to you, but after you heard individuals talk about information, what was the next thing that happened?
We looked at each other, got up and left.
Who's we?
Michael Campbell.
Okay. And when you said got up and left, where did the two of you go next? Was it to a vehicle or walking somewhere? Where'd you go?
We walked to Michael's mother's car.
Okay. Who drove?
Mike.
And where did you believe you were headed at that moment?
To the address. Good question.
Okay. And who did you believe was the address that you were going to, in terms of what role in the world was this person? Why did you believe you were headed out in a car at that moment?
To be honest, I just went.
Okay. Did you go because you believed that that you would be accomplishing something in particular?
Objection leading.
No.
Not at all. Did you go because you believed you would be that you might be accomplishing something in particular?
Possibly more is doing as what we all would do for each other.
What were you hoping to accomplish?
Maybe get some answers, or maybe even see Junior. I don't know.
Okay. And so, other than yourself, who else was in the car?
Just me and Mike.
And about what time, approximately, again, not knowing exact, when did you head out?
4, 5.
Okay. Did you go straight to whatever location you went to?
Yes.
When you got to that address, had there been any change in who the driver was?
No.
So where did Michael park in relation to arriving at this location?
In the gravel driveway.
Okay. And when Michael parked in the gravel driveway, describe what you remember as the vantage point from the road. So if you turn in, what did you see ahead of you?
The house on the right, and then further back was, I seen like dumpsters and like a big green industrial dumpster.
Okay. So in the context of the driveway, did you go any distance into the driveway? I don't need an exact estimate.
Yes.
Okay. And when the vehicle came to a stop, was that because something was blocking it, or because Michael simply stopped it?
Objection leading. He's been doing this consistently, giving the.
Well, no, you don't have. No,
choice.
you made your objection, and the objection is overruled.
You can answer. Go ahead.
What was the question again? Sorry.
Was there something that caused Michael Campbell to come to a stop? In other words, an impediment, a block, or did he simply come to a stop without an impediment?
He stopped on his own.
And when Michael stopped, what, if anything, could you observe occurring towards the house?
Nothing.
Okay. So what happened next? What did you do, and what did Michael do?
We got out and we approached the front of the house, but it was kind of hard to get to. So my recollection was like a lot of bushes and the grass was kind of high. I believe there was no staircase.
Okay, so when you approached the house, did you observe at some point some vehicles located on the property?
Not yet, no.
Okay, so at the point you're at now, where are you located in relation to the house? Are you right up near the house at this point?
Yes.
Okay, then what happens?
We go to our left and back onto the gravel driveway.
Okay.
And then we proceeded to walk forward into the back.
Okay, and is that sort of around the house slightly?
Yes.
Okay, then what happened?
As we approached, we saw somebody with their back to us, is wearing blue jeans and a white t-shirt.
Okay, stop for a second. And could you see vehicles at this point?
Yes.
Up until now, could you see vehicles?
No.
And was the individual you saw between you and the vehicles, or was he on, or were you closer to the vehicles? How were you and he related to the vehicles?
He was directly in front of us.
And between you and the vehicle?
No, the vehicles were off to my right.
Okay. And when you first saw this individual, were they indoors or outdoors?
Outdoors.
And what happened next?
I believe Mike asked him, like, are you...
Objection, hearsay.
It doesn't seem to be an assertion. Objections overruled.
Go ahead.
I believe he turned around because he heard us. And
Well,
Mike...
let me think. It is an assertion.
It was a statement of another witness. It was a statement of another individual, out-of-court statement.
It's a, no, it's not, it actually isn't an assertion, which to me is a claim that some fact exists. This instead is repeating a question which was asked, which is not an assertion. So the objection is overruled.
So again, what do you believe Michael said? What were the first words out of Michael's mouth that you recall?
Are you Zach or Zachariah?
Okay. And did the individual answer?
Yes.
Okay. Is the person who you came in contact with that day, is that person here in the courtroom today?
Yes.
For purposes of the record, could you indicate where the person you came in contact with on May 19th is located, and say what they're wearing today?
He's to my right. He's wearing, looks like a green tie, light blue shirt, and a dark blue jacket.
I'd ask the record to reflect identification of the defendant, Your Honor.
He's indicating the accused.
When the defendant was asked if he was Zach or Zachariah, what did the defendant answer, if anything?
He said, no, that's my brother.
And then what did either you or Michael say next in relation to the defendant?
The objection potentially calls for hearsay.
Well, what because
Said
what the witness said, he's a personal, has personal knowledge.
True.
So it's not hearsay.
No, but the question was.
He asked, what did you or?
Right.
So it's half hearsay.
Well.
But I'm not even sure it's that.
We didn't get to it yet, but depending on, the question needs to be, what did you say? And if the question is, what did Michael say? Well, that's hearsay.
Judge, two individuals.
No. Why argue? Ask him if either he or Michael said anything.
Did either you or Michael say anything?
Yes.
What was said next?
Objection. Same
Well,
objection.
but ask which one said something.
Did you say anything at this time?
No.
What did Michael say then at that time?
All right.
That's hearsay.
And well, I don't know yet. I have an overwhelming suspicion that it's non-hearsay.
Well, the last time we thought that, a few minutes ago, the answer was, are you Zach? Was the question. And that is clearly offered for the truth of the matter. So it's an out-of-court statement.
No. We're not going to agree, and I'm not going to rehash it.
Okay.
I'm actually going to chance it and take the answer. So go ahead.
You don't need argument from me then? Is
No.
that okay? So what did Michael say next?
Actually, Zach said something before Mike said something.
What did the defendant say next?
He said, what do you want with my brother?
Okay, then what was the response that was made by, well, let me just ask, did you do the talking in terms of any discourse or discussion specifically with the defendant?
Me and Mike both did. We conversated with him.
Okay, so what was said next by the two of you?
After he said, no, that's my brother, what do you want with him? Mike said, well, our friend Junior's missing.
Same objection, Judge. I don't know how this is not hearsay. I really struggle
Because
there.
I'll tell you what-
Because this witness is going to testify. But now they want to
I'll
double
tell
up
you
on
why
it.
it's not hearsay.
Okay.
It's because, first of all, he's on the stand, subject to cross, and he is testifying to what he heard with his own ears. To the extent he's repeating what the other gentleman said, I don't see it as being, it is not being offered to prove the truth of the matter which is asserted.
Perhaps you didn't get an offer of proof of what it is offered for because.
No, because we're going to move along.
Okay.
The objection's overruled.
Can there just be a standing objection in this?
No, there can't.
Okay, thank you. I tried.
Well, no, you did, but in 1978, the revisers of the evidence code says, oh no, you can't have standing objections.
What year was that?
78.
Okay, thank you.
I was, well.
All right, Mr. Hendrickson, again, after the two of you were asked, what do you want with him? What was said?
Mike asked him, we want to talk to her, like, we just want to know because our friend Junior's stuff happened at his apartment, and Mike was said to him, I know that, your brother and your brother's ex have been, and Junior were dating or seeing each other, and after that, I really don't recall what Mike was saying to him. I don't remember if he said anything back, but Mike basically explained to him why we're there because we know that your brother and our friend had problems.
Okay, so do you remember the defendant reacting to hearing the news that our friend Junior is missing? And we know that your ex and Junior were seeing each other, dating, something like that?
Yes.
Okay, so having heard those two pieces of information, what, if anything, did the defendant do in reaction?
He said he can call his brother and ask him.
Then what happened?
He started kind of making his way to the house, which was to his left.
Okay, then what happened?
He got into the house, and me and Mike walked back to where we parked.
He, meaning the defendant?
Yes.
Okay, and when he went in the house, and you and Mike walked back to the vehicle, how did you go back to the vehicle? What route did you take?
But we took the same route we took going up to the driveway.
All right. How many vehicles were in the driveway, if you remember, that were not the vehicle you guys came in?
2.
Okay. And if you remember, what were the vehicles? Only if you remember.
It was a black car and a dark colored minivan.
Okay. And did you at any time approach either of those two vehicles?
No.
What's the closest that you got to those two vehicles in your estimates?
20, 30 feet maybe.
Okay. And then, and what about Michael? Did he ever approach either of those two vehicles?
No.
And was Michael ever out of your sight during the entire time you were at the property that you described?
No.
After you got back to your vehicles, at your vehicle, obviously I mean Michael's mom's vehicle, what happened next?
We kind of leaned on the hood of the car, I guess expecting him to maybe say, hey, my brother's car. We just walked back and sat on the hood of the car and basically just waited to hear some news.
What's the next thing that happened?
We heard his voice. And
his meaning the defendant?
The defendant. We heard the defendant's voice. Mike spotted him through, I think, a screen door window from inside the residence.
Then what happened?
He asked, what do you guys want with my brother? Or, started having, an aggressive tone.
Then what happened?
Mike was like, we're just here to figure out what's going on with our friend. It's cool. Have a good day.
And then what happened next?
We turned around, got in the vehicle, and backed out and left.
Okay. Who drove, if you remember?
Mike.
Then at some point, did at some point, were law enforcement contacted by Michael and yourself?
Michael.
Okay. And were you, I don't want to know the details, but were you present when that occurred?
Yes.
I have no further questions.
Good afternoon.
Good afternoon.
Good afternoon, Mr. Hendrickson. I want to walk through a little bit what occurred on May 19th, 2020. When you arrived, you said you walked to kind of behind the residence,
After we went to the front, yes.
and you saw two vehicles. You said a dark-colored van and a black car.
Yes.
Did you see anyone in the van?
No.
Did you see anyone cutting out a carpet in the van?
No.
Did you see anyone burning any items?
No.
You said you saw Mr. Anderson,
At the time, I didn't know it was him, but yes.
and you saw what he was wearing.
Yes.
You said it was blue jeans, white shirt.
Yes.
Did anything about his appearance seem odd to you?
No.
Now, you said that you were there to just have a conversation with Mr. Anderson.
Like, what do you mean?
You'd agree that it was more confrontational than conversational.
No.
No. Were you there to sell cookies?
Objection, that's
Obviously
argumentative.
not.
Oh, hold on.
Oh, sorry.
Objection, argumentative.
Well, in the lesser sense, yes.
Were you there to speak to Mr. Anderson about nothing important?
Same objection, it's argumentative.
You know, I think the jury's been very patient with us. I think we need to move this along and not ask questions that don't go directly to what's being sought after.
Sure, Judge, but when the witness
Do
says
what I said.
you were there on serious matters, according to you, right?
Yeah.
And you had never met Mr. Anderson before.
No.
And this was not your property, right?
No.
This was private property.
Yeah.
If you have a home, Mr. Hendrickson,
I do.
if two random people showed up to your home and were asking some pretty serious questions, would you feel that it was a friendly encounter?
Objection, again, it's argumentative, Judge. This is this is argument.
You understand you're under oath?
I do.
That's not a proper
Oh.
question.
When you went to Mr. Anderson's home on May 19th, 2020, did you have a firearm with you?
Absolutely not.
When you left Mr. Anderson's home, did you get pulled over by law enforcement?
No, we did not.
Did you have any sort of contact with law enforcement when you left Mr. Anderson's home?
At the time, no.
After this had occurred, had anyone from the district attorney's office talked to you?
It was a while afterward, I believe. First,
Who spoke to you?
I can't remember.
Okay. And you said Mike had called 911
No, he called the Mequon Police Department
directly.
directly.
When you were there, you had testified that you didn't see anyone burning anything. Did you observe a fire?
No.
Nothing further.
Is the time period that you got there, can you estimate what time of day you got there?
No, it was getting dark though. So whatever time it was during that period, I don't know.
So May 19th, at whatever time period it starts to get dark on May 19th?
Yes.
Okay. Nothing else?
Any question?
To that point, it was dark. Was it raining?
No.
On the 19th of May, is your question?
When he was there, was it raining?
At the defendant's house?
Correct.
No, it wasn't.
Nothing further.
You may step down, sir.
Time for a break, Judge, so we can break up our witnesses rather than start one. And
All right, 10 to 15 minutes. Please don't talk about the case. Read, watch, or listen on any count of the clock. Told one of the bailiffs that she thought that the officer who was here, the evidence man, say his name?
Giovanni.
She thinks he might be related to her husband, but not closely. And I think, did she say she hadn't even ever met him?
I think that was part of
Yeah.
the conversation.
So she's aware of a relative she's perhaps never met.
Oh, lots of people have those,
Okay.
and some I wish I hadn't. But and in fact, the Thomas case that was just affirmed by the Supreme Court a week and a half ago was involved a juror who said she thought she might be related to one of the witnesses, but she wasn't sure, and I kept her on the jury, and the Supreme Court said, don't worry. But you're aware now, and if you want to question the jury, you're welcome to do so.
We do not wish to.
Is this all the information we know?
Well, do you know that juror's name? Could you identify?
If I understand it, she thinks that he's related to her husband in some distant fashion or semi-distant fashion.
That she thinks she.
She said that.
Okay. Was there any discussion about like how close her husband was to him? Okay.
Well, it is something we need to deal with at this hour, but I think before the day is done, we need to address it if you want to take it any further.
Okay. All right. We'll discuss it. Thanks.
Okay. Anything else?
I do need to get a couple of exhibits marked.
Um,
I'm fine grabbing the stickers, but I know that Paul is keeping the ticket.
hmm.
Sure. I believe I need Noll had 0.
designed to modulate your voice. Oh, did you find it? Oh, and it's still intact. Usually they tear apart. Oh, sorry about that. Yep. Be my guest.
So the state has on multiple occasions introduced evidence through testimony about Mr. Gutierrez being a loving father, a loving son, someone who's concerned about, being there for his kids, painting this picture of his character. The defense believes that opens the door and allows us to introduce evidence contrary to that assertion that's been made by the state. Miss Noll was a victim of abuse of Mr. Gutierrez, and I would plan on asking whether she was aware of Mr. Gutierrez ever being violent towards women he was dating.
Now, I have to say, I think I made a little instruction to the jury that I wasn't going to let the district attorney go too far into Mr. Gutierrez because we treat the taking of human life the same regardless of the character of the victim. Or at least that's what we tried to do. And the district attorney did go on a little bit, and the Ms. Karaskevich made the,
Zerek, Judge. Just like
yes, made the totally unsupported assertion that a single mother is more devoted to her children than others. And I think, what are you talking about? There's no data on that. But so there were some things said that really don't bear on this case at all. I'm not saying they're not as loving with their children, but a lot of women and men have very intense love for their children, regardless of whether they're married or unmarried. So, but that was just in a series of statements that you made and evidence that was produced about Mr. Gutierrez. But it was at that point that I spoke to the jury and told them that I was going to limit that evidence because it was totally irrelevant whether this man was a man with 27 prior convictions or was lived his life like Mother Teresa, is totally irrelevant to whether the state demands that anyone responsible for his death be brought to justice. So I don't see why we're going to add anything to show that he was a bad person either.
So another point of this is that the defense anticipates on inquiring in line with law enforcement not investigating other potential leads. The fact that law enforcement knew or should have known of Mr. Gutierrez's past conduct with several of his romantic partners, that being this violent history, and that they did not investigate any women that were potentially involved to question them about a possible altercation. And so I guess the inquiry from the defense would be then, if the court doesn't want us to ask this particular witness who would have the foundationary knowledge to establish that, I'm comfortable then just asking the the detective at a later time, but what I don't want then is an objection for lack of foundation.
Well, if it's extrinsic evidence, that's the key factor. It is distracting the jury from what they're here to determine. It also places the district attorney in the position of being the only means by which Mr. Gutierrez's reputation could be defended, and the district attorney may have been the prosecutor in those instances. I don't think that has a sufficient probative value to reach the surface.
If I could, Judge,
hold on. Let me respond before we get the double trouble here.
I'm comfortable with that. What I've already said. Comfortable.
I don't think the names are needed.
I am comfortable with what I have already said.
Okay.
No, that's fine. I was just commenting that I don't think the names from the
You don't need to
state
comment.
are
You don't need to
necessary.
comment. If you have a comment, if there's an outcome that you feel is unacceptable, you can comment then to the Court of Appeals.
So
Okay.
the court's made a ruling and we should bring a
I
witness?
have indeed.
Okay, thank you.
We have to get the jury here first.
Well, I know.
I didn't hear what the comment was.
I'm willing to repeat it at some point when it's appropriate if the court wishes.
I don't need to.
Okay.
Would you come down, please?
Okay.
Okay. Come on.
Your call cannot be completed as dialed. Please consult your directory and call again.
Can you just hold on a second, please?
This matter will be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated.
Could you please state your name for the record and spell both your first and your last name, please?
Aileen Noll, Ailennnoll.
And are you currently employed?
Yes,
And what do you do for work in general?
I work in the pharmaceutical industry.
And where do you currently reside city-wise?
In Racine.
Do you know someone by the name of Rosario Gutierrez Jr.?
Yes.
And back in May of 2020, how often would you estimate you saw Mr. Gutierrez Jr. on a weekly basis?
A couple times a week.
And what was, at that point in time, your relationship with Mr. Gutierrez Jr.?
He was a friend and then also working for me.
And when you say working for you, what was he doing for you?
He was a contractor, so helping fix some of my units.
Do you flip properties or do something of that nature?
I have rentals, and I did flip at that time, did flip houses.
And Rosalio would assist with that?
Yes.
And was that a consistent thing he would do with you multiple times a week?
Yes.
And approximately how long had he been working for you in this role as a contractor for flipping properties?
It had been a few years.
And for your jobs, did you know him to be punctual?
For me, yes.
Now, you also indicated you and Mr. Gutierrez were friends at that point?
Yes.
And saw him on a very regular basis?
Yes.
If you were going to estimate for us, as someone who knew him, what would you estimate his height and his weight to be at the time of May of 2020?
Maybe 6'1", 220.
Now I'm going to direct your attention to April of 2020. Do you recall Mr. Gutierrez ever coming to you as a friend regarding a relationship he was in?
Yes.
And what was the name of the person he was in a relationship with, if you know?
Sadie.
And when he came to talk to you, do you recall when this was?
When he was in the relationship?
When you had this conversation with him regarding Sadie?
Yeah, the first time it was a Saturday.
And in what month, if you recall?
I believe it was April.
And what was the nature of the conversation he was having with you regarding his new relationship with this Sadie?
Objection calls for hearsay.
Your Honor, it ultimately is going to be not for the truth of the matter asserted, but it leads to a name she's able to provide later on to Michael Campbell.
It's a conversation that allows her to know how she gets the info.
What information did Mr. Gutierrez tell you about this relationship in context with this case?
No, that last part, that
What information did he tell you in regards to Sadie the Saturday you spoke to him in April?
Again, the same objection is clearly for the matter asserted.
I don't know that it's as clear as you suspect.
Well,
You have the advantage that you have all the discovery in that, so I don't have that, but to me, it's not so clear.
Well, if it's not,
And it's non-testimonial, so it can be approached a little more,
either way, how is it relevant?
I don't know yet. It actually, that may be the weakest feature of it, but you can answer.
What was the nature of your conversation with Mr. Gutierrez that April Saturday?
He had let me know that he was in a relationship with Sadie, and he had spent the night with her that evening before he came to my house. He had talked about an altercation or something that had happened where someone had broken into his truck or got into his truck and
Judge, again, this is. Can we briefly let the court know where it leads?
It's time. Give us a minute. Well, go ahead.
Okay. So the relevance.
Could we do this outside the presence of the witness? Because otherwise, he's just coaching her.
Well, I don't know that I agree with that. Go ahead.
So this witness hears from the individual from Rosario Gutierrez that someone Sadie's ex-boyfriend has broken into his truck and been monitoring him and been filming him. So he hears those things. So when Miss Noll, who is the original person who begins to alert the friend group, hey, where is Rosalio? When she does that, and when she provides the both law enforcement and when she provides Michael Campbell and his associates the name of the person, she is providing a name of a person because she has heard who Sadie is. She's had recent information about this incident, and so that's why this name comes up. That's why these people go visit. It explains exactly why all these people do these things. So it is the centerpiece of why Aileen Noll is not picking a random person in this situation. So remember, the defense in this case is that you should have focused on X, Y, and Z persons. Well, there's a reason why law enforcement and people close to Rosario Gutierrez, et cetera, continue to focus.
That would have been true. In fact, it was true in the case of the state against Jensen, the letter from the grave. This is very close, really, to that. And
this is not testimony. That was
a testimonial statement. I agree with you.
This is.
But we're working with hearsay here, even though the hearsay rule is in a steep decline. It's still the law.
Sure.
And
but it was found to be.
This is other than the testimonial aspect. This is I think remarkably similar to the letter from the grave in the Jensen case.
Well, he wasn't alleging that he was about to be killed or any of those things. He wasn't alleging, hey, look for this suspect.
Providing the motive.
He is indicating. Well, you're going to hear that motive from Sadie, who's going to say she's an eyewitness to some of those things. You're going to hear it from the daughter, who's going to say I was a participant in some of those things. So you're going to hear direct witnesses who talk about experiencing that going through. But it doesn't help the jury understand why Michael Campbell and his associates know where to head. Remember, there's been an accusation these people have interfered with the investigation. Remember, there was an offer of proof made. Well, the counter to that is that Aileen Noll has heard a conversation from this individual, not meant to be told to law enforcement. You don't report this to Aileen Noll to get the cops to intervene. You tell Aileen Noll because she's a friend of yours, and when it's reported to Aileen Noll, she simply stores that away until a moment where now he's missing, and so she has one particular person who she's going to look up and maybe provide information to others about. That's it.
So based on that, we get to get into everything this dead person says, or the supposedly dead person we don't even know. I mean, I agree about the Jensen analogy. It's just dead on point, and it's clearly testimonial. It's also, if we have Sadie and Olivia.
It's not testimonial.
Well, if we have all these other witnesses that are going to talk about all this other stuff to counter the defense's theory about law enforcement, then that makes this even less relevant.
That's not true, because Sadie doesn't speak to Michael Campbell and those people. Aileen Noll is in contact with those people. The daughter is not in contact with Michael Campbell, etc. The only person is Aileen Noll in that regard. And so, they hear this information and they are directed that direction partly because Aileen Noll here's enough information, Sadie, ex-boyfriend of Sadie, to be able to put two and two together and direct them in a particular direction. And so, again, Judge, this is, right now what the jury is left with in the alternative is, well, how, unless these people are directly in on this, do they have a way to go and find this random guy? They've never spoken to Sadie. They don't know any of these people. And so how are they randomly going to find this guy on the planet?
I don't know, but that doesn't change the rules, and the fact that we're not allowed to. Now, I'm not speaking of this particular testimony or this witness, but you could get a lot of common gossip in with that kind of an explanation. Gee, the jury isn't going to understand this unless you let in this gossip. That's not the rule.
So then, by his theory, then I guess she directed Campbell and his friend to go over and threaten Zach. Is that somehow helpful to the state's theory? I don't get it. I don't understand the purpose or the relevance of this.
Did I purport that? Did I?
No, you didn't. No, you didn't. But to me, it's the non-testimonial letter from the grave. And it's banned under the hearsay rules as they stand. The proposal, the practice in England for many years has been to let the jury have it and let them work with what it is. That's the proposal for the federal rules, but it's not in the federal rules yet, even though it's widely practiced, and it's not in our rules.
I do feel this court has in practice been fairly has thought about the hearsay rules and had you and I have had personal discussions about hearsay on many records. I think this moment certainly feels familiar to you as it does to me, and I have often had an expression on my face similar to the one I have right now because of my thought process that the hearsay rule should be much stricter. And the court on those days has talked to me about how you have an expansive view of hearsay and believe that a jury should hear it. Now, again, every case is different, so I simply don't in any way mean that the court is changing its mind in sort of philosophy, but I would suggest to the court.
No, it's not that at all. It's that in the Jensen case, I said the evidence couldn't come in. And your office appealed, and the Supreme Court reversed. So I had to try the case the whole time knowing that it was going to go down in flames, which it did, until the DA's office was finally compelled to keep out that part of the case. That was the letter from the grave. And now you are back with the same type of evidence, except it's non-testimonial.
Well, luckily, we're under much wiser leadership now than what the court is portraying in terms of prior. Judge,
Well, I think what you're saying, Judge, is that it's not going to come in, so we should move on.
He was talking, and the jury's sitting in the back, and he's right. We have feuded over hearsay, and I think he has misunderstood what I've said on it, but he does understand that we don't agree. Ask the jury to come in, please.
So he can't get into this?
The objection will be sustained.
Thank you.
So she'll indicate
You may be seated.
Ms. Noll, moving forward to May 15th of 2020, do you recall having a discussion with Mr. Gutierrez regarding an upcoming scheduled install at one of your properties?
Yes, was that Saturday?
May 15th, I believe, was a Friday.
Friday, yes.
I'm going to approach with what's previously been marked State's Exhibit 4-3. Put this up on the screen here. Specifically at the top here, would the green messages here on the right side, would those be from Mr. Gutierrez to you?
Yes.
So he says to you downstairs.
Sorry, you have to answer out loud.
Yes. Yes.
Yes.
So he says to you on May 15th at 4:53 p.m., downstairs tenant is scheduled for Monday for lights install. Is that accurate?
Yes.
And you indicate back, great, what about the hall light?
Correct.
And he indicates back to you, I'll do it on Monday when I do the other ones.
Yes.
And you indicate back, okay.
Yes.
And May 15th would have been a Friday, so Monday would have been May 18th. Would that be accurate?
Yes.
And so the plan here is he's going to be doing work on one of your properties that day.
Yes.
Was that work ever completed by Mr. Gutierrez?
No.
Now, page 2 of this document is a message from you. From May 17th at 1:52 p.m. It reads, I don't think this setup works right. The water drains too slow and backs up, and the water is sitting in the disposer. Do you recall this conversation with him?
Yes.
And is this regarding something at your personal home?
Yes.
And does Mr. Gutierrez then respond with a couple of messages on May 17th all the way up till 2 p.m.?
Yes.
After May 17th at 2 p.m., do you ever hear from Mr. Gutierrez again?
No.
Now, subsequent to him not showing up on May 18th to do the install at your properties, do you attempt to reach out to Mr. Gutierrez?
Several times.
And how do you attempt to do that?
That Monday morning, I had texted him to see if he was getting over there, and the iMessage went through as a text message, which usually meant his phone was off. I got busy and didn't follow up until the next day. I texted him, and the same thing. The iMessage went through as a text. So I tried to call him, and it went straight to voicemail. So then I called Michael Campbell.
And was that unusual for Mr. Gutierrez's phone to go right to voicemail for 2 solid days?
For any day, yes.
So then you just indicated to us that you then reached out to Michael Campbell. Is that accurate?
Yes.
I'm going to show you what's been marked as State's Exhibit 244. Is this blue message from you to Mike Campbell? It says, hey Mike, hi Mike, sorry to bother you. Have you heard from Rosalio the last couple of days? I tried to call, but it goes straight to voicemail.
Yes.
And was that from May 19th at about 2:08 p.m.?
Yes.
Objection, hearsay.
These are
As to what Michael Campbell was going to say?
The objection's overruled.
And then do you actually identify yourself to Mr. Campbell so he knows who's communicating with him?
Yes.
And then Mr. Campbell says back to you, I seen him Saturday. Is everything okay? Is that accurate?
Yes.
And you indicate back, I was checking to see if he was...
May I see it? The objection is overruled.
So you indicate I was checking to see if he was able to get the lights installed in the other unit and hall,
That's correct.
and then you indicate just making sure he is okay, not like him to have his phone off.
Yes.
And Mr. Campbell indicates, okay, I'm due some detective work for you.
Yes.
And you indicate, okay, thanks, just making sure he's okay.
Yes.
After having these interactions with Mr. Campbell, who had also didn't know where Mr. Gutierrez was, what did you do next?
I was working that day, so I'm sure I continued working, and then Michael called me to let me know that he was at the apartment.
And when Michael called you to let you know he was at the apartment, whose apartment was he at?
Rosalio's.
And what did you do after hearing that information?
I went there as well.
And what, if anything, did you see when you arrived at Mr. Gutierrez's apartment?
Just the police tape around the apartment.
And did you attempt to speak with police regarding any information you had?
I tried to at that time, but they were busy.
And ultimately, did you have further discussions with Mr. Campbell away from the scene a little bit later on that night at roughly 6:15 p.m., 6:18 p.m.?
Yes.
Apartment 2, Mr. Campbell had further discussions regarding your concerns about Mr. Gutierrez's disappearance.
Yes.
And did you both know of someone that Mr. Gutierrez was somewhat concerned about in the weeks before he went missing?
Yes.
I'm going to show you page 2 of Exhibit 245. At 5:19 I'm sorry, on 5:19 at 6:18 p.m., did you send a name of a person that you knew Mr. Gutierrez had talked about previously to Mr. Campbell regarding your suspicions in this case?
Yes.
And is that name Zachariah Anderson?
Yes.
Judge, I would move to admit exhibits 243, 244, and page 2 of 245 into evidence.
Objection?
No objection except for the last one and the subject to the redaction of the first text, which parties agreed on.
That's accurate.
All right, received.
Thank you. so I'm giving you both pages. My pay grade.
Judge, the defense has no questions for this witness.
You may step down.
State calls Michael Campbell.
You solemnly swear the testimony you're about to give in this matter
Yes.
will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Please be seated.
Mr. Campbell, we need you to speak into that microphone. The acoustics are a little rough in here. Okay, if you could just speak right in there. Mr. Campbell, can you state your first and last name, spell your last name for the record?
Michael Campbell, Campbell.
How old are you today?
42.
And in general, what profession do you have?
I own my own business.
And in what basic community or city do you live in?
Kenosha, Wisconsin.
And where were you raised?
Kenosha.
In your life, did you come at some point to know a person who you knew as Rosario Gutierrez?
Yes.
And what name did you call that individual?
Junior.
So I'm going to refer to him as Junior for purposes of our discussion. Is that all right?
Yes.
How did you know Junior?
From Bradford High School.
That's where you met him?
Yeah.
And what can you say about, in general, what can you say about the friendship since Bradford? You said you're 42? Been a few years since Bradford, correct?
Yes.
So let's talk about the time period of May of 2020. How would you describe your relationship with Junior during that period of time?
I was working with him, so it's pretty good.
Okay. And other than the work relationship, were you guys in any other way companions, et cetera?
Yeah. I mean, we hung out all the time.
Okay. And at that time, did you have a girlfriend who also was in your life?
Yes.
What was her name?
Erica.
And and what, if anything, can you say about whether she was a person who would see Junior as well during that time period of May of 2020?
Yes.
Now, I'm going to turn your attention to the time period of, again, May of 2020. What kind of work were the two of you doing?
Painting, flooring, whatever would pay the bills. I mean, general contract work.
And what was the relationship between the two of you? Were you partners? Did one of you work for the other? Can you describe that relationship?
He had his own business. I had mine, and we just kind of worked together. He was better at finding jobs, so it's kind of why I teamed up with him, because he was really good at that, and obviously had all the connections with investors and stuff like that. So.
And have you at some point? Was there a time on May 19th, 2020, that you became concerned about Rosalio Gutierrez?
Yeah, I believe so, yeah.
Okay. So on the 19th, so that's a Monday,
Mm-hmm.
what was the first contact that somebody had with you? Sorry, it was a Tuesday, apologize. What was the first contact somebody had with you that Tuesday that led you to start thinking or wondering about Rosario Gutierrez?
I got a message from Aileen, and she asked if I heard from him, and I said no, but it wasn't unlikely for us to go a few days without, you know.
And who was Aileen so that she would get in touch with you?
She was an investor that we both worked for.
And so when she contacted you and asked you if you knew where he was or if you'd heard from him, what did you do in response to that?
I told her that I haven't heard from him, and I could find out, you know.
Okay. And what'd you do next? What's the first thing you did to try to find out?
I went and paid my truck payment, I believe, and then I drove past his house, and then.
Let me ask you first, did you call him?
I don't recall. I honestly don't remember.
Okay. So when you drove past his home, had you been to his home before?
Yes.
Okay. And what did you see there, if you recall?
Crime scene, you know, a bunch of police tape or whatever, caution tape.
If you had a general estimate, do you know about what time you would have arrived there?
I don't know. It was afternoonish, I would say.
Okay. And when you got there, did you make yourself known to law enforcement in some way?
Yeah.
Let him know. And what'd you say to him?
I said, well, they approached me and they asked, what are you doing here? I was like, looking for my friend Junior, and then that's when they just started asking me questions.
And what, if anything, can you say about whether you provided them information at that time?
What was that?
What, if anything, can you say about whether you provided information to the police at that time? Did you tell them some things?
Oh, yeah. I mean, I told them everything that I, knew and whatever.
So did you give them, for instance, some names of people they might want to reach?
Right. Yeah. Other friends and.
Do you remember who you told them?
I know one of them was Jeremy Kipp. I wasn't sure with the new boss that he was working with down in Waukegan or wherever it was. I didn't know his name exactly. I don't recall any other ones, but.
Do you know if you gave the police Aileen Noll's name, or do you know?
I probably did, yeah. I mean, because obviously that was the reason why I went over there, so.
So after you were at the scene and saw the police tape and asked your question, what did you do next?
I just went home and was just trying to gather my thoughts. It was very, scary to me.
Okay, so let me stop you. Who was home when you got there, if you remember?
At my house?
Yep.
My girlfriend at the time.
Okay, is that Erica?
Yes.
All right. And what, if anything, did you do next that you remember?
I just was talking to her about the whole situation, and then just, I guess, doing our own investigations.
Did anybody else arrive at your house at some point?
Yes.
And who was that?
My friend Brandon.
And in general, how did he come to arrive at your house, if you know?
What do you mean?
Well, did somebody call him?
Oh, no, he was in town getting, I believe, a tattoo done or something, and he might have called me, or I might have called him or something. Maybe he called me because I think he seen my post on Facebook asking if anybody has seen Rosalio.
Okay, so you posted something on Facebook?
Yeah, I believe so, yeah.
Let me finish my question before you answer.
Sorry.
Okay, so my question was, did you post something on Facebook because of what you saw at Rosalio's home?
Well, because I was told that he was missing.
Okay.
So.
And so at some point you were in touch with this other individual, and his name again?
Brandon.
Okay. And so Brandon, where did you meet Brandon or see Brandon next?
He came to my house.
Okay. When Brandon got to your house, what happened next?
We just got the information, found his address, and went to his house.
So in general, do you recall how you got anybody's information?
Facebook, and I want to say maybe CCAP. I'm not sure.
And if you can you tell me who you remember getting information? So like, who was it who was finding this information, if you know?
Erica was getting the information.
All right. And did you then at some point believe you had the name of a person that you were focused on?
Yes.
Okay. So my question is, how did you come to have a particular person in mind that you felt you guys should be looking into?
Well, I mean,
All for speculation and hearsay.
I don't think this question does. The objection is overruled.
So again, how did you come to be focused on a particular individual worth looking up?
Well, it has some risk of getting some hearsay. Be ready to be interrupted.
do what you got to do, buddy.
The start.
Did you hear what he said?
Yeah.
Do what you got to do, buddy.
Yeah. You go ahead and start.
So I was working with him, obviously, and he had
With we don't know who him is.
Junior, sorry. And he had mentioned to me.
All right, there we are.
Okay. So based on some discussion or conversation you had with Junior, without telling us what that conversation was, did you have a name or some reason to look up a particular human being on the planet?
The question still calls the basis of it
It
is
does. It is. Yeah.
the exact same thing.
It doesn't ask what.
Lawyers will argue about this.
Okay.
But I have to agree that it's pregnant with hearsay.
Okay. After any discussion you had, when you discovered that Rosario Gutierrez was missing, who did you then focus on? Was there a particular person who you focused on?
Yes.
And who was that?
Well,
Same objection.
not exact. Well, it's the same objection. It's a little bit different. But
Revealed no content. He's simply saying,
yeah,
I
well,
now went to look at a particular person.
yeah, we could argue about this till we're blue in the face, and it won't do any good. I mean, the lawyers see it differently. It has huge potential for hearsay, and I'm going to sustain the objection.
Did you focus on a particular individual? Without telling us why, did you focus on a particular individual?
Yes.
And who was that person?
Zach.
Okay.
Zachariah.
And did you know that person's last name?
Not at the moment, I don't think.
Okay. How did you...
Judge, I'm going to interpose my same objection because just by skipping over the part that the court wouldn't allow him to get into, he now is in an area that has no connection, no evidentiary connection, so he can't get to where he just went to.
That's not true.
Well,
you don't have to have any basis.
Okay.
Yeah. As I say, I'm not going to make the jury endure listening to us haggle about it. It is, we'll call it hearsay seepage is what we'll call it. And we'll break for the day. Please don't talk about the case. Read, watch, or listen to any count. And let me ask that you return at 9 o'clock tomorrow morning. Yes. In true amount.
Lawyers are not going to agree on this on both sides, but it's a vehicle to get the composite result of the hearsay into the minds of the jurors to prove the basic confines of the hearsay. And they think that because they didn't get the exact words out that they've complied with the hearsay rule. But in the end, what the jury ends up with is, well, of course, he acted as he did because of what was told to him. Even if we don't know exactly what it is, we know that it triggered a response of fear in this case. So I think it's hearsay.
What was the last thing you said? I missed the very last thing. Your
It
voice
triggered
dropped.
a response of fear in this case, and so that's why it's hearsay.
Because of the response, because it caused him to do something next, drives it into the category of hearsay. Because it
Something
caused.
so alarmed him about what was said to him that he took that next step.
So these are statements that were made days or weeks prior. So these are not statements that prompted him to take any action until his friend was missing. When his friend is missing, he has a prior conversation. It's weeks old, or at least several days old. I guess I don't want to say multiple weeks, but several days old. And it causes him to take specific action, which is to look up one particular individual. At this point, the court has indicated that we cannot say what the content of that conversation was, right? That was a prior ruling. So I did not ask that. I said, without telling me anything about what the content of the ruling is, what a conversation, when he went missing, did you focus on a particular individual? And his answer is yes, and he will now say who that individual is. That isn't hearsay. There's no specifics that have been presented. Simply what we're talking about is simply that based on whatever was said to him, whatever nebulous items were said, here's what he did next. This is his motivation. It isn't, I didn't ask him based on any conversation.
But it's clear from the historical events which have already been discussed, the source of his fear.
So, Judge, how?
And Judge,
let me, if I could just briefly respond, counsel. I apologize. How else would we have a jury understand that they didn't just drive randomly and stop at house to house on the way to Mequon? I guess what I'm trying to say to the court is this is they went to a particular address which they looked up, and I don't imagine the court is saying that I can have no witness say that we looked up an address and that we then proceeded there. I don't imagine that you're saying that, but I'm at a loss, and maybe I just don't understand.
Let me explain.
Okay.
Supposing what had happened is Ms. Gutierrez had given a sealed letter.
Yep.
to the witness and said, if anything happens to me, I can tell you this is what happened to me with Zachariah Anderson. And it's a poison pen letter. It's the one that Walter Raleigh lost his head over a statement like that. God, I love it. The judges said it's the darkest blot on English jurisprudence. It's a poison pen letter. That's what it is. It doesn't make any difference. You don't have to prove to the jury why he went there. He did go there. What you are doing here is the defendant has thrown the bait into the water in opening statement, and you've been continuously responding to it. And I'm not criticizing you. Don't misunderstand. But that's why I've talked to the jury. you're getting a lot of stuff that would ordinarily be classified as hearsay, but isn't, because the defense opened the door to all this. And this is just more, but in this case, it's just too much. Because it's actually, well, maybe because of my experience with the poison pen letter.
You do seem a little wounded.
Little what?
You do seem a little wounded because of the prior district attorney. Sounds like. Okay, so I think the guidance from the court right now is that he can indicate where he went next, but he can't say anything about what his basis is on which arriving at that.
I'm not going to advise you.
Well, okay.
But
All right.
I would think that would keep
plan.
you, might keep you out of trouble.
My current plan is that I will ask, was research done, and did you then proceed someplace? And then that's all I'm going to do.
As I say, I'm not going to
Understood.
comment.
Okay.
All right.
Objections,
Pardon me?
there may still be objections, but.
Oh, I don't doubt. I don't doubt that. And I apologize for very abruptly ending things, but there's the same issue I talked about earlier. It may be, actually, we won't need the break tomorrow because we may. It may not be necessary to take a break tomorrow for that situation with the medical visit because I may do it today. So that's why I'm going to leave here.
Oh, you're okay. Instead of Thursday. Now I understand. Thank you.
But I don't know.
Okay.
Oh, with Thursday was the original. Well, anyway, we're done for the day.
Okay, thank you.